Really on the stand, sweating bullets in the dock. Defense attorney, taco spitting fire, won't stop. Really stutter, trip up, his story take a dip. Taco's got him caught up, words slip from his lip. Questions come rapid, really shaking in his shoes. Reputation crumbling, got nothing left to lose. Tacos play him like a fiddle, make him sing a tune. Relly's getting tangled, courtrooms like a saloon. Relly sweating, drip, drop, saying nonsense. Tacos got the crowd leaning in the suspense. Witness falling fast, tumbling like a rock. Tacos cross-examining, ticking like a clock. Relly's words are weapons, turning back on him fast. Defense attorney slaying, got him in the past. Each lie unraveling, spilling from his mouth. Relly can't remember which way's north or south. Got the jury snickering every single time. Defense attorney sinking, reading every line. Relly losing notion, don't even recognize. Tacos got him pinched, looking so demonized. Relly sweating, drip, drop, saying nonsense. Tacos got the crowd leaning in the suspense. Witness falling fast, tumbling like a rock. Tacos cross-examining, ticking like a clock.
Hello, folks. How are you all doing? How are you all doing? I'm doing much better. Thank you so very much. If you asked, the antibiotics seems to do good for me. Seems to do good for me. And so, yay! Here I am for a limited time. Limited time. Once I start coughing like a madman, then we will find something for us to do. We will find something for us to do. And hello in the chat. Hello, Gwendolyn, April, Fun Size, Neo Dark Matter, Berta, Chicky Brewer. Hello, Slidey Pie, and the rest over at Rumble. And hello, you over at X. There. Hello, folks. Why am I not in the middle of it? So, for you at X, hello at Rumble, hello at YouTube. Do the things. You know what I mean. Thumbs up, or the heart thing, or the whatevers. Subscribe or follow if you haven't yet, because subscribe, yeah, and do all the things. I'm doing great. View wise on X, I'm doing great. I have quite good numbers. YT, YouTube, but seems to have me in some sort of shadow ban because they decided my channel. I don't know. I have 20-25% of my normal views. Maybe I simply don't know. I'm doing the same things, I hope, that I've been doing for the past 2 years. That has allowed me a growing number of subscribers, an steady increase in views, and all of a sudden, a month ago, 75% gone. Well, subscribers are still there, but basically nobody's getting notification. Now that was an issue even before over at YouTube. But now it's getting ridiculous. I did a non-scientific survey on my YouTube page. Do you get notification? And I got, how many answers did I get? Well over 100 answers, I believe. Let me just check this. I'm not assholing you on that one. Dun, dun, dun. Well, combined 100 something, and maybe one or two actually got notifications once in a while. So there were more people who said they don't even see if I'm live. So they have to go actively on my page to see if I'm posting something new or if I'm even live. Then the people actually get notifications. Don't know what I did wrong. Do not know why YouTube decided to hate me, but I'm going to push through it like a bad cold or pneumonia. Hello, Paulette. Hello, horse welfare. Hello, everybody. Hopefully we can, once I get better, now I said this on postings on YouTube. I will have a members only stream first, where I go through with the members what will happen, what's in the channel going forward, because there will be some change. Hello, Paulette. Hello, Steph. Hello, folks. So this is just me whining a bit before we get to the real stuff. Now, I knew there was a YNW hearing, Melly hearing today, and I had it loaded to watch it after the fact with you guys in this verdict watch, which it actually is. We are, let's see here. Dun, dun, dun. There it is. We are here. They have, as of 50 minutes ago, they are deliberating. So, yeah, we are at verdict watch. Let me get a banner up. So I went over there, and now to show it to you guys, the YNW Melly. But it seems like CBS Miami, who streamed the hearing, then took it down. So I don't have it. I wish I had it, but I don't, and that's a bit infuriating. Because now it didn't really happen that much, because the update everybody's interested in is Melly's ex-girlfriend hearing coming up, because she was arrested on the airport and then put in jail and then put in an ankle bracelet, a GPS monitor, and the hearing is on the 21st, I think. Don't know if that will be streamed, but they are challenging her being in ankle bracelet, because I believe, if I remember correctly, they say that the subpoena was for the first trial, and they haven't updated it, so there's no actual basis for the ruling to put her in a GPS monitor. Hello, Christine. Hello, Christine. Hello, Wendell. Mr. Jingles just went outside. He will. I hope he will return, because about an hour ago I saw a mouse skittle across the floor, and but Mr. Jingles was asleep at the time. So hello, DSN. Hello, DSN. Hello, Slider Pie, says Overdrop and Nick. So good to see you feeling better. Thank you. Yeah, I've been on antibiotics for pneumonia for the past week and a half or so. And Sunday, it finally, it was a clear shift. It was a clear shift. So, yeah, it was liberating to finally be able to breathe properly. And I still have a few days left of that antibiotics sequence, whatever's. Then I'm going in for a new checkup, and yeah, hopefully my lungs are free from fluids and stuff. So yeah, where were we? Yeah, YNW Melly hearing. I don't have anything to show you. So what I will show is the Karen Reed hearing from today, which, if you haven't seen it, was a bit of a jaw dropper. It was a bit of a jaw dropper. I also have let's see here, before I say, before they started today in the ASAP Rocky, before the jury sat down, they had some kind of hearing. And let's see here, I had also something I had up. Sorry. Dun, dun, dun. Where did it go? Where did it go? Yeah, there. Over there. There. Hi. Now, what happened today before the jury went in for deliberation? Well, Lewin, of course, like the whining little 3-year-old with the temper tantrum, went off again, apparently, and accused Mr. Lewin for being unethical by bringing up the Ninth Circuit decision, where the Ninth Circuit concluded that Lewin is a lying liar who lies. Because Lewin represented to this judge that, you know my ethics, you know I wouldn't lie. Well, now we have a Ninth Circuit decision, including you, Mr. Lewin, as a lying liar who lies. And for you guys who don't know, what about this Ninth Circuit decision? Well, the case was a murder case way back when. Sadly, it took a good while for that murder case to reach the PS courts and stuff. But in that, Mr. Lewin got a third-party culprit defense excluded by a person who was seen with the victim just a few hours before the murder. He got that excluded as of no nexus, if you have ever heard that before. And then in trial, Lewin argued before the jury that the victim was alone the entire night leading up to the murder, which was a lie. A simple lie, because he knew she met somebody that evening. Just hours before the murder, she was seen with a person. He knew that, and he still represented to the jury that she was alone. And that is extremely exculpatory, because if you get information like that excluded, it's not like it stops existing. But it's still represented to the jury as if nobody was around. It had to be the defendant. In clear violation. You can't make that argument if you know it is untrue. And Mr. Lewin said to the judge, "I will go under oath," which is also something incredible, in my opinion, because as an officer of the court, you are always bound by the code of conduct. Always. In front of the judge, in the courtroom, you are bound by it. It is the equivalent of being under oath. So Mr. Lewin saying, "I will take the stand under oath," means nothing. Because, Mr. Lewin, you lie under oath, or under the equivalent of an oath as an officer of the court. We already know you're a liar. So you claiming, "I will take an oath," is worthless, because you, Mr. Lewin, don't care about oaths. You simply don't care. That is extremely infuriating. Knowing that Mr. Lewin, I won't say that he does this without batting an eye, because he was throwing a temper tantrum, as per usual. But we will see what happens with that, because also we have Taco, who represented to the court a judge, Mr. Lewin. When in his closing argument, he showed a manipulated video for the jury. It was not the video as they presented in the trial as evidence, where the gunshot was timed in at least somewhat. No, in closing argument, in the video that was shown for the jury in closing argument, the gunshot took place a second and a half, 2 seconds before, making it look like it came before the fight. So yeah, Mr. Lewin, we know about your ability to lie in front of the court. We know how you, without any scruples, will manipulate evidence. It is clear as day that Mr. Lewin will do anything to get a win, included but not limited to lying. evidence tampering, and so on. We already know that. Hopefully, the jury picked up on it. Hopefully. Thank you. So, now what do we have in... So that is what happened. I thought I would do that before. So, instead of that, while we wait... Oh yeah, before I forget. Lewin asked for 90 minutes. After the jury says, hey, we reached a verdict. He asked for a 90-minute delay. Not this an hour or the top of the hour. No, 90 minutes. This despite Mr. Lewin's office is less than 5 minutes away from the courthouse. He could be there in 5. No, I need 90 minutes. Why? Because he's an entitled little brat. Spoon-fed, spoiled, entitled little brat. Welcome to my show, by the way, if you're new here. I say snark. I do snark. I say words you might not agree with. If you don't agree with it, I accept any constructive criticism. That is the lifeblood of litigation. Constructive criticism. The lifeblood of a proper channel. A proper streaming channel. I will not accept the right-out lies. I will not accept spam, of course. And if you actively try to bring my channel down by saying a lot of bad words and instigating stuff, I will throw you out. But constructive criticism, just aim correctly. And we'll have a discussion about it. But yeah, this is today's Karen Reed hearing, which hopefully, we can have some fun with while we wait. I will have... Well, if they haven't said anything before... What time is it now? It's 7:30 p.m. over here. If we haven't heard anything within 4 hours, I will simply... well, hopefully they have reached a verdict before that. But hopefully, if not within 4 hours, I simply have to go to sleep because I have a work day tomorrow. Yeah. Okay. So are we ready? Are we ready for some Karen Reed shenanigans? All right. Dun, dun, dun. And again, hit the thumbs up, you know all the things. And be active in the chats, please.
22-117 Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the
Good
Commonwealth.
morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning,
Good
Your Honor.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for...
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
And I start with the sidebar. Of course, I do not count sidebars in hearings. I will save that to a trial. Oh, it's the ceiling fan. It's ceiling Dion. So let's skip ahead. There you go.
So, What I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night,
Okay.
and on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement and the order is right here, Mr. Clerk. All right, next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right, so paper number 483, this is the motion to compel production of a forensically signed copy of the January.
Okay, I just saw from Kathy Russell that they got footage from the motion arguments this morning. Upload to the YouTubes. Coming soon. Let me check if it's already up. If it is, I'm going right in to it. Dun, dun, dun. No, it's not there. Let's just see if it's on the network. Nope. We will go through this one first, and then as soon if the verdict isn't in yet, we will go through what happened this morning in the, I believe it is sanctions hearing, because both parties seek sanctions on each other in the ASAP Rocky trial. It's Trinto says it doesn't sound like it's there yet, but huge props to Kathy for their clip game. Yeah. Ever since Kathy came on board a couple of years ago, Law and Crime has upped their game.
2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number?
I do, just a second.
Okay.
I'm sorry, the opposition too.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument and you can give me that.
506,
Great, thank you.
that's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan, We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, et cetera. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a...
Yeah. That iCloud account we were so mad about a couple of weeks ago. It turns out it wasn't an iCloud account. It never was. Apparently. It was Canton PD, in the Canton PD electronic saving whatever's account. So there is probably a full download of all the videos. It always have been. And they find this out after the first trial. A few months after the first trial. A month and a half before the second trial starts. Now they find out that all the videos have been saved this entire time. Yes, Mexican Vader. The state constantly lies and misleads the defense counsel at every opportunity. I shouldn't be surprised, but I still... Now, what I do believe is good, because I don't think with McLeland at the rudder, they would never have found out. So for this, I'm thankful for Mr. Brennan, that he actually tells the defense, here's what's going on. And then, of course, he will do what he does, try damage control and everything. And we will hear his counter argument later here. But I must say, without Brennan, a lot of things here, the defense would never have found out, because the Canton PD would have hid all of this indefinitely. I'm actually surprised it's not destroyed. I'm actually very surprised that it wasn't destroyed by the Canton PD. I don't know. Hey, look at this. Hey, Mr. Jingles is here. Hello, Mr. Jingles. Hello. All right, let's keep listening.
Retired officers or retired detectives' work computers iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well.
Yeah. Now, why is metadata this important? Well, it will show when was this downloaded, and it had to be downloaded from the original system within 30 days of the 2020. Within 30 days of the original recording, it had to be downloaded to this. And in this system, every log point should be saved. Since they use a system where you have to log in to your computer and then go in and access, in this metadata, you will see who went in and took out information and when. So metadata here is probably almost more important, but depends on what's on these videos, of course. If we actually see the proctor and the rest, if we actually see them with a crowbar starting to dismantle, yeah, that's important. But I do believe that the metadata, who accessed it, that is important. Because there are Brady violations here. Extreme Brady violations here. If they can see that Proctor, Paul, or any other of these corrupt cops accessed the system before, during, and after, Detective Bukaki, before, during, after, if they see that they did have it and didn't turn it over, that is probably one of the worst Brady violations I've heard of, if that is what the defense can find out. So yeah, will be interesting to see the outcome of this.
And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for.
Yeah. This request from the defense is very reasonable. Very, very reasonable. I don't see why not. But we will hear Mr. Brennan argue why they shouldn't. But first, Love versus Money 68. Thank you so much for your $5 super chat. That is very generous. Just saying thanks, hoping to start a gold train for those who just want to show support. Oh, thank you so much. And I did. I set a goal. 10 super chats, $5 each within an hour, $5 or more. And I will get Mr. Jingles a new toy. Okay. That will be displayed on the next stream. All right. Thank you so much again. Thank you.
Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files.
Yeah, as it says, everything done to those files is logged as metadata and in the log system. All that information. And since this should have been in the hands of the defense before the discovery breakout point, and they don't find out about it until now, they are not only well within their right of having it. There should be no objections from the state whatsoever. But we are talking about Massachusetts, apparently.
The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that, in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR where they full well knew that I had no idea if there was still video on there, and why would there be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence.
They weren't accurate because they weren't given the accurate information, Mr. Brennan. Now, I gave him credit before, now I'm taking it away.
To have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I'll always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petra, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he
Metadata from the DVR is useless because it's not the original. I hear that freaking mouse. Go on. And off Mr. Jingles goes. He heard that. Good kitten, good kitten. Where was I? Yeah. What's on the DVR is useless. It's absolutely useless. And I can't believe he's making this argument. Oh, they get independent metadata from this DVR. That's not how it works.
He's a detective, and he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. we said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed under the spirit of Brady violations and due process. It was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today we have done by the end of the week.
You want to maybe, I'd be heard briefly,
Yes,
very, very briefly.
take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the
October 24th, did that video come with the metadata?
No, it's just video. It's just a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, and again, I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. Is the metadata associated with all those things? It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs or what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the video. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
This is the stage for Mr. Brennan forcing Karen Reed to pay for another trip, another $12,000 plus for that expert to come to this extraction thingy. Instead of just, here's a full extraction with metadata and everything. Just videotape it and we're good. It's not good.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit.
Yeah, before we play this, I'm actually torn here. I know Mr. Betterow is an excellent attorney. Excellent. With his knowledge, with his he's just a really good attorney. But he represents Aidan Kearney, Turtle Boy. I personally, because of the allegations of witness tampering and everything, I would stay the fuck away from Karen Reed if it was me. But he's not me. And if the prosecution and the court doesn't find a probable, possible, or even theoretical, if they don't find a conflict of interest, he should be at the defense counsel's table. That's not my issue here. It is the visuals of it. Because the so-called anti-Karen Reed out there, they will feast on this. And I've seen them feast on this and make all kinds of allegations. But it's not me who decides. It's Karen Reed. And I'm not in her shoes. But if it were me, and I were Mr. Betterow, I would stay the fuck away. But yeah, there shouldn't be even an argument to make. The allegations, everybody can throw allegations around. It's like assholes. Everybody has one. Well, most, if you don't have a bag on your belly. But we know that Canton PD, Judge Bev, and the prosecution, they're waiting to make the nexus between Karen Reed and Turtle Boy with all the allegations of misconduct and witness tampering and everything. And they've been trying for years to find that nexus. They haven't found any nexus other than Turtle Boy, reporter, with a passion for this case. And here's Karen Reed. And there's been contact, but for him as a reporter. Now, if they share attorney, that, yeah, there's nothing to stop them, I think. But the visuals of it is not good, in my opinion. So, yeah, but let's keep listening.
But as soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes,
Maybe her brief.
yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not
this would
entitled
be
to any product of
the
a
state's
mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are
response
not
to this.
co-defendants.
This
It is curious
expected. They've been
that given the
trying
indictments,
for
most of them
years
that deal with
to make this
witnesses
argument.
in this case that allegedly have been harassed and intimidated. It is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery.
What
And
we're
much of that
saying
was
here,
turned over subject to a protective order.
what's-
And I expect
Mr.
there'll be a
Brennan,
similar.
what's your actual legal argument? This is him begging Judge Bev. We don't really have a right to it, but please, 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 pretty please, with sugar on top.
Motion, Mr. Kearney's case, within 24 hours of the violation in this case, it was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage.
Yeah, I understand him. I understand the argument here. Two different clients who are not co-defendants. Well, welcome to the public defender's office, who always have, it's his argument is more or less you can only have one client. You can only represent one client at a time. You can. It's not even close. It's the, for me, it's the visuals of it. But they still can. But be damn sure in this retrial here, they will do anything to make this argument in front of the jury.
And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not.
Order Dr. 911. What court order got violated? Did they actually file any details? I don't know if we got there yet, or if we are getting there. The end of this hearing is absolutely fire. So stick with it, because I haven't seen this myself. I've heard about this. Is about when I stopped watching because I had to prepare for this stream. So from now on, I have no idea what's going on in this hearing, but I heard it gets absolutely wild.
Leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Court. Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide the defense copy if they want.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of I'm sorry, page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. Secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this
is a real thing. Even though the prosecution might say, "Oh, we would never do that." No, but that was the argument unsubstantiated regarding the using of Miss Reed hiring Mr. Bedero. But here, because in the first trial, it was apparent that some of the witnesses either followed and listened to the trial and made adjustments, or they got information beforehand. So giving up these things beforehand only helps the prosecutor's witnesses to prepare for impeachment. Because when it comes to impeachment, one factor here is surprise. If you have information that somebody is going to lie on the stand, you don't want them to know about it. Hello, Mr. Jingles. Did you catch it? Did you catch it? I will find out. I will find out soon. So it's the element of surprise for the defense. Well, you said this, but how about this? Yeah, and this is, as Max conveyed, the state is not entitled to a fair trial. It's in the Bill of Rights and the Constitution. This new thing that, oh, it has to be equally fair to both parties. For frick's sake, the state has more or less unlimited resources. In order to at least try to level the scale against the government, all the rights are with the defendant. But when most judges are former prosecutors, this is what we get.
Is a, I won't say unique trial, but it's a rare trial that, you know, is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, you know, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought there were 2 points that you made both two.
Understood, understood.
All right, so, Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that.
Unless the rules are completely different in Indiana, in Massachusetts, from most other states, the defense only have an obligation to turn over the things they intend to use in their case in chief, not impeachment material.
Reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything.
Experts are completely different from a fact witness. Completely different.
Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they
that you're asking for impeachment material, and the examples you use are experts, completely different from a fact witness the state calls. Now he went into, well, they have an obligation to turn over things when they call a witness. completely correct, in their case in chief. But you're not asking for material in their case in chief. You're asking for impeachment material for your case in chief. That's different.
They have evidence they're going to use at trial. They have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already.
Well, now when I listen to his argument for them to turn over comes back to what I said earlier. He's using the rules that applies to the defense in their case in chief in order to try to get impeachment material for witnesses the state calls in their case in chief. That's not how that Rule 14 works.
In place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this length meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right.
Intent. Here's what I think is going on. Now, Mr. Brennan is hired to do the Commonwealth's bidding. So, but what he does do so far, he is actually handing over discovery, even though he argues that he shouldn't have it. So, yeah. Timmy G. Brennan is a snake. Well, at points, he's almost playing both teams here. But if we have to give him props for anything, is that if this was still the original prosecutor, none of this would ever have found its way to the defense.
Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with.
So you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions, one before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage, another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State.
That's actually really huge. There's no custodian of records. At least nobody revealed. I do believe it's an obligation of every police department to have a custodian of records. Not entirely sure with smaller precincts, but a precinct the size of Canton PD, definitely. There should be a custodian of records.
Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize.
Oh, they're gunning for it. I'm here for justice for Sandra Birchmore. Folks, they are gunning for it. Yes, there are many people in both investigations. If you don't know about the Sandra Birchmore case, I have some videos on it. Sandra Birchmore her death was first ruled self-ending. Then a medical examiner concluded, no, it is a homicide. She did not take her own life. Sandra Birchmore was groomed from the age of 13 by police officers. Groomed as a sex toy for them. These PDF cops used her and abused her for years as their own personal doll. Then one of these PDF cops got her pregnant. At the same time, his wife was pregnant. Sandra expressed she's keeping the baby. And everything I've seen so far tells me he took her life. And as it seems, that more or less a bunch of cops which are intertwined with this case actively hid evidence, in my opinion, actively try to make evidence go away. If this case can get this reference between the Sandra Birchmore case and this case, with dirty cops covering for each other, because if cops in this region here, Canton PD and surrounding police precincts, if they have the ability to cover for PDF file cops, then this is nothing new. Question is not if, it's how many times they have covered up for murders in Canton and surrounding police precincts.
First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach
Also,
Clark.
Albert was involved.
Colleen Crawford. Lieutenant John Fanning. Trooper Guarino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey.
And Michael
All
Morrissey.
of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers.
I completely agree here. Mr. Farwell and his brother, who both raped and groomed Sandra Birchmore, and then Mr. Farwell murdering her, allegedly. and cops covering for them. That goes to credibility, if not criminal culpability.
And their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility. In our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request, objecting to it, particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
Yeah, they didn't even object. Probably because in that case, it really doesn't help
It's
them
important to
oppose it.
represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked a chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to.
Mr. Brennan here publicly admits that the Canton PD actively does not follow protocol, actively does not have a chain of command or chain of custody in writing. Why do you think that is? Let's speculate, because it's easy. If you don't write down what you're doing, then you can't be impeached with it. Then you can get up on the stand and lie. How about that for a theory? In this case, I don't think it is a conspiracy theory. Mr. Brennan just said it. They can produce what doesn't exist. They do not have. Because Canton PD doesn't care. Now, in my personal opinion, if there is no chain of custody recorded, whatever evidence that is should be thrown out in its entirety. Because if this happens in a murder trial, it's going to happen in a shoplifting, or in a theft, or in a home invasion, or in somebody making false claims. If you are falsely accused of something, hey, after the fender bender, he attacked me. And the cops that show up collects the evidence in solo cups and used paper bags, and then don't write down correctly, don't know chain of custody. How are you supposed to defend yourself if the Commonwealth, as in this case, against somebody the Commonwealth already decided that person we believe in? Don't give a crap about the evidence. Hey, Hip Comic. Yeah, I saw it earlier. I'm still waiting for the motions hearing from this morning before the jury went off to deliberation. I saw it about an hour ago, and I hope they will upload it soon. Soon. But we will check this first,
I've
and
done
then
my
we
best
will
to be
watch
thorough and
that.
diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto, And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble.
Okay, a little update here. Yuri is out to lunch. So now with that, nothing will happen for at least 2.5 hours. First an hour lunch, and then we know that Mr. Lewin lying, however he chooses to be named, or how he chooses him to be named, he is asked for 90 minutes from the time they have a verdict until the reading of the verdict. So we have 2.5 hours ahead of us.
And search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case?
Because it is your witnesses, the cops you have to put on the stand, are also involved in that case. That's why it's important.
Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing.
Saying it has nothing to do with this case when they just said the names of the correlating officers between that case and this case, including a person who did the extraction of Sandra Birchmore's phone, and then they claimed, hey, we didn't find anything on it. And then the feds checked the extraction, and all of a sudden, I believe the number is 34,000 text messages between Sandra Birchmore and her abusers. 34,000. That's kind of important. Hi, Phoebe. Hi, Phoebe. Hi, Siobhan.
But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty.
Again, I hate to say it, but if Brennan weren't there, we would not have any of this. Morrissey and the other four quads would not have handed any of this over, not volunteering to anything of this. So even if we believe he's sneaky and he does bad arguments and everything, without Brennan, the defense wouldn't have this. None of it.
Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that.
Yeah, in the last trial, they put on Trooper Paul as their experts. It seems as if they are planning on outside experts this trial. But that also might mean that the defense will call Trooper Paul.
tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
I can
over
give that to the
500 at
court.
this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition.
I haven't read this motion myself, but I've heard other lawyers talk about this motion. I listened to a lawyer you know, I listened to a bunch of them, and it's poppycock. There is more or less no reason to exclude the ARCA experts. None whatsoever. Both the Commonwealth and the defense had access to the ARCA experts. The same exact information was handed over to both parties. The defense chose to call them to the stand without knowing what they would actually testify to. The prosecution chose to not.
.505. So, Mr. Brennan?
Thank you, TLF. Yes, I'm feeling much better. Thank you so much.
Sure.
And the goal ended and we didn't reach it, but thank you folks for trying. Thank you. I will get Mr. Jingle some treats instead.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason.
That you can ask them yourself. in a Daubert hearing. That is not a reason for excluding them. This is speculation at best, guesswork. We don't know. Well, ask them. Put them under oath and ask them. But Brennan doesn't want to. He wants them excluded instead.
So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've
Same as with the last trial. Both parties had access to the exact same. It is up. This is not a motion towards the defense. This is a motion the state should make against the FBI, who hired them. But they don't want to. Because if they find out, if say they are successful in a subpoena towards the FBI, and oh my God, this is so much exculpatory, we have to hand it over. They don't want that. Fun side. Did you see the interview with Turtleball and one of the jurors? I've seen parts of it.
read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
So he did ask the FBI and then got stonewalled. But that's the same. You have the same. It's no difference between you and the defense then. Unless you can actually show they have access to more than you have.
So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Information provided by the defense and reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and
Remember what he said right there. This is not information that was provided by the defense. Remember those words.
and insistent the best I can to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results.
But this is between you and the FBI. This is between you and the FBI, Mr. Brennan. If now, after the trial, FBI decides to share more information with you, you have the obligation to share that with the defense.
In a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So,
Again, remember, he said he did not. He said he received this from the FBI.
I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before we begin.
Court, all rise, please.
So, with this new information from Mr. Brennan, she takes a recess. And apparently, she's furious about the representation here from Mr. Brennan. Let's see if they ever come back. Yep, here they are. Let's see if they actually caught him correcting himself. Because this was material he got from the fucking defense. And he represented to the court, in open court, that he got it from the FBI and not the defense. This is Brennan lying to the court.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
It's Trinton says. He didn't realize she did this solely on the oral argument without a response. Yeah, she took his word for it. And as it turns out, Brennan's word here is absolutely worthless. This was not handed to him from FBI. It was handed to him by the defense. They gave him this material. And this invoice of $23,000, as he represented, I don't know the content of it as of now. Jackson has said outside, that it's complete BS. Complete BS. And here's the thing with this invoice. ARCA is no longer hired by FBI. Their contract is gone. It's over. It lapsed some time ago. So if the defense wants to have them as their experts. Now they have to hire them. So this might be a prepayment for trial number 2. It might be travel expenses because they chose to call them to trial number 1. Oh, Angela Thompson said, thank you for clearing that. He said it was for their travel expenses. Yeah. Because if the prosecution had called them, they had to pay for their travel. They chose not to. And in order for the defense to use them as witnesses, then they had to pay for their travel expenses. That's a non-issue. And the reason why we are at this point in this hearing right now is because Mr. Brennan lied to the court, saying, I was handed this from FBI, which is a lie. He was handed this information by the defense. Hi, Derek. Oh, we are 2 hours and 20 minutes in. Yeah. So it's a bit. We are currently at verdict watch in the ASAP Rocket trial. The jury is on lunch, so they have not reached a verdict yet, and we are at least 2 hours from the reading from a verdict because they're on lunch. Then they will come back from lunch, and even if they say we are ready, we're with the verdict directly after lunch, Lewin has asked for a 90-minute delay before reading of the verdict, because even though his office is 5 minutes from court, he asked for 90 minutes. And we just, no, I think, wait, there's more.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests.
Oh, what's that, Mr. Brennan? The defense also wanted more information. You just happened to forget to say that before Judge Bev said, accused the defense for misconduct to the level that can jeopardize their representation of Ms. Reed in this trial.
Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that,
oh, you both got answers. Why didn't you say that in your initial monologue?
that the contract had ended with the ARCA experts, and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025.
The defense provided you with the emails. How convenient that you just forgot about that. You're in open court as an officer of the court with every obligation equivalent to an oath. You left that piece out. You said, this is what I got from the FBI. You lied to the court. Having Judge Bev believe, oh, the defense tried to hide this from you. And now, all of a sudden, no. Everything he read from was provided to him from the defense, not the FBI.
I think I said the federal government. It was the defense. February 13th, 2025.
Oh, whoopsie. I think I said the federal government. I meant the defense. Again, I will say this, without Brennan, most of everything, the videos, the new videos, the everything, the defense would never have known that the prior prosecution team are liars. But now we know. And then he goes around and misrepresents to the court who actually provided him with this information.
They sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
No, this is not
Your
federal.
Honor, may I hand up the
This is state
discovery
court.
that was
Thank you.
provided by the defendant reference side.
Oh, great, thank you.
Is there any way she was small for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live.
I'm amazed the defense is as calm as they are with this. But I do believe it is because they know that Brennan up there was pulling crap out of his ass, representing to the court this was information from the federal government when it was in actuality from them. He got all of that. Oh, sorry, it's Trinton. Let's see here. Memorandum in support of a petition to writ of habeas corpus. Reid moves to end the trial based on double jeopardy. That is in federal court. Yeah, that's in federal court. Thank you.
I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
Thank you.
Let's see here. Okay, we are closing in on the end of this hearing, and it is a clusterfuck, absolute clusterfuck. And for me, shows that even though I have to give Brennan some Fox for actually revealing stuff to the defense.
Your Honor, we'll accommodate the 25th, one way or the other.
All right,
And
so we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
yeah. Where were we? Yeah. It's, even though I have to give props to Brennan for actually giving the defense things they should have had years ago, the way he ended this hearing with a complete misrepresentation. Because if he had that invoice, he could have read, okay, what's in the invoice? If it said travel expenses, it would have been a nothing burger. And this hearing would have just kept going, maybe. But he riled up Judge Bev to the point that she threatened the defense to more or less remove her attorneys. And so, yeah. Angela Thompson says, love the beard. Thank you. I had to trim it because the past week and a half, I've been just sick like a dog, pneumonia, coughing up and everything. So the big beard, it's so hard to maintain when it's full of gunk. So I chose to. Nick, how much of this case has to do with the Birchmore case? They have 8 or 10, something of the sort, cops and investigators who worked on the both cases. And both cases are about cops covering for other cops. Let's see. Again, I love the bit. I need a pretty face after watching that mess. Oh, thank you. Thank you so much. Thank you so much. And I see it's her first super. It's your first super on a live stream. Thank you so much. I'm very honored. I'm very, very honored, Angela Thompson. I'm very, very honored. Did I donate the hair? No. I will not voluntarily get stuff away that might contain my DNA. Not because I do anything bad. I just don't want anybody to have it. Once I'm gone, way in the future, once I'm gone, do whatever you want. I'm dead. I won't care. But that is 20, 30 years in the future. Oh, yeah. And it's the same district attorney, Mr. Morrissey. Oh, so yeah, this is a faster clock. And it keeps, it's just getting worse. It keeps getting worse. Oh, Angela says, I watch you in Cat a lot, but something told me today was the day for my first super chat. Oh, thank you. Thank you so much. Thank you, thank you, thank you. And the goal is 10 super chats within 2 hours, and I will get Mr. Jingles a new toy. Yes, Mr. Jingles is here. Let me just get, I will have this one up. Yeah. Hello, Mr. Jingles. Hello. Did you catch the mouse? Were you a good kitten? Did you catch the mouse? But thank you so much, Angela. Thank you. All right. Next thing on the agenda, because I'm still waiting for, because this is verdict watch for the ASAP rocket trial. before the jury went to deliberation, there was a hearing, a sanctions hearing, and apparently it was wild. Law and Crime says they have the recordings of that, but they haven't posted it yet. So still waiting for that. So what I will do is there is an update in the Delphi case. And who is Yuri? Yuri Bukaki. Or Buchanan, Bukhari, yeah, whatever his name is. He is just one of these assholes in Canton PD. But as I said, we have some updates in the Delphi case. Let me first get one of these up and going. It's a swoop. Yes, my swoop is the Norwegian firefighting dragon. A few weeks ago, the attorneys in the Delphi case against Richard Allen had motions to correct error to the court because of some misrepresentations that was being said in court. Misrepresentations about evidence, misrepresentation about Mr. Allen's mental status before he was arrested, and FMD mine. This is not FMB Diamond World. This is not the forum for you. This is not the forum for you. Create your own channel, make your claims there, but not here. Okay? Okay, starting over, because I will cut this out to a separate video. That Delphi. Well, they had this. The defense filed a number of motions for correction of error. And what does Judge Gull do? What do you think she did? Well, let's check it out. Order issued. Defendant's motion to correct abstract of judgment filed January 20th, 2025, reviewed and denied without a hearing. This I'm not familiar with, but the important stuff here, reviewed and denied without a hearing. Then it comes to this. The court have received defendant Richard Allen verified motion to correct errors filed January 20th, 2025. The state response to motion to correct error filed February 4th, and the defendant's verified motion to strike the state's response to motion to correct error filed February 14th, now denies defendant's Richard Allen verified motion to correct error and further denies the defendant's verified motion to strike the state's response to motion to correct error without hearing. Now, what was all of this about? Well, it is it's evidentiary issues. It is things that the state did. For instance, the white van. Remember that one? The white van that the prosecution claims, this shows that Richard Allen knew things only the real killer would know. And they made the claim in trial that that happened at 2:32 p.m. Was it 1:32 p.m.? No, at 32 minutes past the hour. They made that claim in court. Then, after the trial, we find out that there is video of the white van not being there at 32 past the hour. It was there at the absolute earliest, 45 minutes after the hour. Now you might say, well, 13 minutes. What does that matter? It matters because the prosecution knew all along that what they said to the jury was false. Absolutely false. And they did it anyway. So the defense wanted a correction of error, saying the prosecution knew this video showed what they said in court was not true. And Judge Gull denied it without a hearing. As she always does. She doesn't care because she's a disgrace for the profession. She's a disgrace for her law degree and her bar card. She's just a disgrace. It's hard to put up a defense against allegation when the judge, who is supposed to be an impartial gatekeeper, decides, no, this guy is guilty and I'm going to help the prosecution. So yeah, and this Ken Reed trial has similarities with that, the Ken Reed trial. Now, this is not the only order. At the same time, this order happened. Defendant's motion to preserve specific evidence, filed January 20th, 2025, is reviewed by the court. The defendant has cited no authority, either statutory or case law, that supports his motion. This, I believe, is false. The court will maintain the exhibits admitted into evidence in accordance with the trial and appellate rules. However, the court does not have the authority to, quote unquote, order the state of Indiana, including the prosecutor's office and all law enforcement agencies, labs, or state, federal, and local bureaucracies that possess any of the following evidence to preserve said evidence and not destroy or lose said evidence. Here, Judge Gull shows me what an absolute twat she is. She has the authority to order preservation of evidence. That is what this after trial, the motion to correct errors, that is what it's for. It's well within her authority to make this order. Maybe not on federal level, but definitely on state level. So here, she lies because she doesn't care. Denied without a hearing. Denied without a hearing. And she notices everybody. Now this will be appealed. This will definitely be appealed. I assumed she would just let the 30 days run out, but she decided to do this instead, which might come back as everybody expected this to happen. So there's nothing new here. We already know that Judge Gull has no, she's just bad. rotten, absolutely rotten. And but now they can appeal this decision. Sadly, meanwhile, without a decision, they can start destroying evidence. So what will happen? I don't know. We will probably find out soon, hopefully, how they will react to this. In my opinion, with Judge Gull, regardless of which faith you have, if you believe in Judgment Day or not, but I'm convinced that when Judge Gull meets whatever maker you believe in, she will get a soul. That will be her punishment for eternity. She will get a soul. And she will realize for eternity about her actions and the consequences of her actions. She will get a conscience. And that will haunt her for the rest of her time. So that will be her place in hell. Because as of now, I don't believe, if she has a soul, then she has suppressed it for power, for bad deeds, for the ability to put people in prison. She has suppressed her soul. So her punishment, I believe, will be she gets it back. All of it. And the consequences of it for eternity. Sadly, that means that a lot of people will be in prison because of her. Innocent people who shouldn't have been found guilty, people who shouldn't even have seen a trial, are in prison today because of her. And all of that will come back to haunt her. That is I'm convinced, almost, that is what awaits her. Let's see here. And all right, I will put out that as a separate video as well later on. Let's see here. They have a half hour left of their lunch. My apologies. I'm still waiting for ASAP the promised video from Kathy Russen, or from Law and Crime. Let's see here if she's posted anything. No. Dun, dun, dun. Nothing yet. I've been checking here on Law and Crime Trials, but no video upload yet. Let me check. Law and Crime Network. Let's see if anything is up there. Nope. Let's see here. It's Trenton says, I will not to the appeals court if shows she made no effort for due process, care, and consideration to the motion. It's doubtful she even read it. Yeah. Yeah, one of these returning posts. Oh, you found this? Go screw yourself. Denied without a hearing. And she has done that all the time. Now, remember, the only time she actually wanted a hearing was last year. When, no, not last year. It's 2023. When she disqualified the defense attorneys in that case. She threatened them with either you recuse yourself, or I will hold a hearing where I will humiliate you in front of cameras. And the Indiana Supreme Court found that that was wrong and reinstated them, the attorneys. They had the chat. Yeah, the only time she allowed cameras. She has been a big proponent in allowing cameras in courtroom, but we now can conclude that she did that because she wanted, here's bad guys I'm punishing. But the moment it could come back to haunt her, no cameras allowed. And apparently now Indiana in itself has taken precautions or decisions in the standard should not be allowing cameras in court. The standard should be not to allow cameras in court. Because all of a sudden, it seems like she and other judges have realized, oh, we will become under scrutiny. We can't have that. Turning into communist rule of law instead. All right, let's see here. We have some clips from law and crime trials here, which we can check out. Let's see here. Do we have anything fun? Those aren't real clips. Damn, they are long. I mean, you have these top 8 moments in Rocky Gun Assault trial, but that's 4 hours long. That's not really a clip. Hey, Dave. Hey, Dave. Good to see you. Good to see you. Oh, let me get the banner up again. We are on Verdict Watch. And let's get this. Yeah, because since the Delphi case update, I will have as a separate video, so I chose without the live thingy. Dun, dun, dun. Arms, Karma is a B. Yeah, it is. Pray that the appellate court will not stack like God's courtroom. I surely hope so. I've heard rumors, but I haven't been able to confirm it, that Judge Gull is the judge in Indiana with the most overturned convictions. But I haven't been able to confirm it. But I'm amazed if that is true, that she is still allowed to be a judge and be appointed special judge. I'm amazed. Let's see here. Well, we have Monica Cementilli things. Let's see here. Sharing that instead. Dun, dun, dun. A 5'4". I don't know. Is it something with?
With the testimony you may give and the cause now pending before this court, shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. Please have a seat in the witness stand.
This is in California. I don't think this is body shaming when I say I have a hard time with. Now, all cops can't be 6 feet tall and 220. I know that. But at some point, if your feet dangle from a normal chair, maybe you should have a desk job. Not, yeah.
Yes, so you may have to go on motion.
All right, let's check out what's been going on in the Monica Cementilli trial.
Excuse me a second. Detective Staten, spell your first and last name, please.
Sure. Efren Gutierrez. First name is E-F-R-E-N. Gutierrez is G-U-T-I-E-R-R-E-Z.
You may proceed.
Thank you. What do you do for a living?
I'm a police detective for the city of Los Angeles, currently assigned to Mission Division detectives.
What division, I'm sorry?
Mission.
Is that an area of Los Angeles then?
Yes, it's one of the stations.
Okay, and that's with LAPD?
Correct.
And how long have you been a peace officer?
30 years.
Back in January of 2017, what was your assignment?
I was assigned to Operations Valley Bureau Homicide.
And what does that entail?
It's the Bureau level homicide unit, which covers the San Fernando Valley, all the LAPD jurisdiction in the San Fernando Valley.
Did you then respond to 5012 Queen Victoria in Woodland Hills regarding a killing that occurred there?
Yes, I did.
Okay, what time did you get there?
Just before 7, about 6:45 p.m.
Up on the screen is it's previously been marked as People's 9, page 9. Is that the location where you responded?
Yes, it is.
Okay, so when you got there, then what was your responsibility?
So I arrived there and waited for the rest of the homicide squad that was on call. Once they arrived, I did a walkthrough of the crime scene, which included the interior of the house and the backyard, and basically a preliminary viewing of the scene.
And in that preliminary viewing, what did you notice as far as the crime scene?
So I recall seeing blood-stained evidence on the kitchen floor near a slider. The decedent was an adult male in the patio, kind of in a crouch position. There's some wet blood on the ground. Also, I recall seeing, I believe it was a master bedroom, appeared to have been ransacked. There was clothes on the ground and dresser drawers were open.
When you did this initial walkthrough, are you meeting with any of the detectives there?
Yes, as I said, the homicide on-call squad was there. I did a walkthrough with Detective Gene Parshall. He was going to be the lead investigator on the case. And Rob Flirday, Ryan Verna, and Gabe Bucknell.
Now, do you recognize the person sitting over here in the blue blazer with the long dark hair, the female? Do you recognize her?
Yes.
How do you recognize her?
I recall doing a walkthrough with her and Detective Parshall at the termination of the crime scene investigation.
Thank you. So is that a typical scenario where you walk through the residence with someone that lives there? Can you explain why you did that?
So it's standard operating procedure with the LAPD. If a search warrant is served at a location, whoever has control or the owner of a specific location, whether it's a house or a business, we take before photos and after photos and then do a walkthrough with whomever's going to be in control of the location once the police depart and basically describe what we did as far as our investigation and whether or not we seized any items.
So did you spend a fair amount of time with the defendant then going to the different rooms and showing her items that were recovered?
Probably about 15 minutes tops.
Okay. Did you talk to her during this time?
I don't think I said anything to her directly.
Okay. So while you were with the defendant, was anybody else with you when you walked through this house?
Detective Parshall was.
Okay. Did you notice anything unusual about the defendant?
Yes. So my understanding, it was the wife of the decedent. She wasn't crying. No tears, no runny nose. Seemed kind of odd. That didn't look like.
This is something that nobody has said written down in any report. Not one. There's no record of this anywhere. That she was sobbing, but she had no tears. And a prior cop testified only to no tears. That's it. Now this cop shows up and elaborates on that story. That, oh, it was odd because she... Hi, Sleepy. Good to see you. They seem to elaborate their story as they go along, and it keeps getting worse. Now, folks, when it comes to the Monica Cementilli trial, do I believe she had something to do with it? Yes, I do. That's irrelevant. What can the prosecution actually prove? That's the issue here. And my coverage is still on like day 7. And I'm not entirely sure because I'm still on antibiotics for my pneumonia. If I can actually continue to cover that trial the way I did. But everything in this Monica Cementilli trial seems to be an afterthought, just to get her a conviction. And everybody reacts differently. You have dry criers out there who just simply do not produce tears. You have people who behave oddly some time after. And we also found out in the Monica Cementilli trial that her stepson blames her for ruining the marriage between his mom and dad, and have done so for the past 20 years. Why? Well, yes, as it turns out, the victim here cheated on his wife with Monica Cementilli. So both were cheating whores. Who knew? Let's keep listening to this. And then we will go over to Judge Boyd. She's live. She has hearings, Zoom hearings. So that sometimes it has really, really interesting things. It sounds like, Nick, was she convicted? Oh, the trial is still ongoing. It's a 6 to 8 week trial, and I think they are just beginning week 3.
Someone that was grieving.
Have you conducted homicide investigations before where you had to interact with family members, loved ones, something of that nature?
Yes. So I worked homicide for 18 years. During that time, I personally handled 108 homicide cases, and then additional probably 300, give or take, undetermined or unnatural death scenes. So yeah, I interact with family grieving at these type of calls.
And this particular scenario, the defendant struck you as unusual?
Yes, I mean, I'm well aware that people grieve differently, but I thought her behavior seemed odd, a little forced. And I recall telling Detective Parshall that I said she's full of crap when we walked out of the house.
Okay, thank you. I have no more questions. Detective, so when you,
Yeah, he was just there to claim she acted oddly. For me, this is not evidence of crime. This is just appealing emotions. And this guy is definitely not a physician. He's not a psychologist or nothing. Sole reason for him being there was she cried odd. I don't like the. I've been saying this for years. I can say it because I've been, as of now, I've been more than 2 years into this journey. I don't like when prosecutors throw in all of this emotion. If you have good evidence, the evidence speaks for itself. You don't need 6 to 8 weeks for something that should be less than a week. Hey, Lone Star Living, thank you so much for $10 super chat. Hope you get better soon. I'm much better. The antibiotics started really kicking in this weekend, so I feel much better now. Thank you so much. Thank you so much. Getting us closer to the goal, which is getting Mr. Ginos a new toy, which I will present in the next stream. Thank you so much.
back in January, you went to the scene, your role was to do this walkthrough with one of the detectives, right?
Correct.
And you weren't a lead detective on it, it wasn't your case, is that right?
That's correct.
And so, but after having investigated well over 100 homicides and being experienced, this one struck you as different as what you're testifying to because of the lack of what you deem no emotion, no tears, right?
Yes,
Okay, 7, 8 years later now, we're in court. Do you still remember that?
I do.
And does that stick out as different even from that day forward of the continuing investigations you've done of an unusual reaction from a victim?
Yes, it does.
Okay, thank you.
Any further by the defense?
No, thank you.
Thank you, Detective Gutierrez. You're excused.
Okay.
People call.
I mean, absolutely worthless testimony. Absolutely worthless. She cried oddly. It's so much crap for something they really should have evidence for. But instead of actual evidence, they put this guy on the stand. I do not get it. Derek Crossan, thank you for £2. A super sticker with a chicken superhero of sorts, I think. Hey, thank you. Thank you so much. All right, let's get over to Judge Stephanie Boyd. Dun, dun, dun. I like her. I like this judge. Absolutely nothing to hide. The things I've seen with her, she's fair. She can be really rough sometimes. But it's so there are highlights out there with Judge Boyd's court. But here we are, live, half an hour behind, and her usual maybe a couple of hours. So while we wait for the jury to return and maybe with a verdict, they will return in 10 minutes after lunch. How long? Oh, Jennifer, how long has the jury been out? They have been out, well, they are on lunch. Let's see, before they went on lunch, the time stopped at 3 hours. So they have been deliberating for 3 hours, which is nothing for a trial of this magnitude and length. So, oh, Mr. Genius, do not boot me with your claws, please. Huh? Please. All right, let's listen to Judge Boyd.
Yes. Thank you. And what time did you want it, Ms. Abrams? Okay.
And not,
Okay, let me call him. All right, Ms. Abrams, that's been added. Jury trial. So how was your jury trial?
It's still going on. I have a sentencing on Monday.
Well, you know what Cornelius would always tell me?
What's that?
You can win, defense attorneys should win every single case that they try,
Oh, yeah?
if they can write their own facts.
Yeah, if we could. That's better.
Oh, that was funny. Oh, that's so funny. Oh, that's so funny.
All right, so this is scheduled for jury trial. How long do y'all expect the trial to last?
Probably about 3 days, Judge.
All right, so y'all want to confer with Ms. Ferguson on the jury trial date?
Okay.
All right, and then just let me know what the jury trial date is. Thank you for dressing appropriately for court.
Thank you.
All right, so if you'll just have a seat, they're going to confer on a date, then you all give me that date, please. All right, do not wave to people in the audience unless you want them removed from the courtroom. This is not visitation, okay? Richard Baker.
We're here, Judge.
All right, Mr.
In action this morning, robbery case over in juvenile.
All right, so is he?
He's present. I have yet to talk to him. I just showed up from.
All right, so
They
why
kept
don't
me
you-
at juvenile till almost 1 o'clock.
Okay, if you'll speak with him,
Yeah.
and then just let the clerk know when you're ready.
Yes, ma'am.
All right, they're not ready on this case.
Okay.
Yeah.
Catherine Grabs. Thank you.
yeah.
Court is calling 2024 CR 009739 State versus Catherine Grabs. Can I have parties announced for the record for the state?
Megan Valerie for the state. Lindsay Shaw for Ms. Grabs.
And are you Miss Grabs?
Yes, ma'am.
All right. Off the record for a moment. In this case, is there any restitution?
No, Judge.
Okay. All right.
The store received the items back.
All right. Thank you. We're back on the record. Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
All right, excuse me. Deputy Laura, the lady in the check shirt, if you could take her out, she continues to speak to people in the box. All right. The court will find that the state is in compliance with discovery. Is there an application?
No, ma'am.
All right. Ms. Grabs, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Ms. Grabs, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property, 2,500, 2 or more previous convictions as a state jail felony?
Yes, ma'am.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered the plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Krabs, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 20 days in the Bexar County Jail. Under 1244, there's a $500 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
I'm assuming that outside the agreement, the defense is requesting that the defendant serve the 20 days request of Bexar County Jail on GPS. Is that
Yes,
correct?
Judge, and that's what we had worked out with the state. I can elaborate on that if the court so wishes.
Well, outside the agreement, it appears that both parties are asking that you obtain GPS and that you serve 40 days on the GPS monitor as opposed to being in the Bexar County Jail for 20 days. No contact with HEB stores, partial ELM, and allowed to work at your current employment. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plea?
Guilty.
State, any evidence?
State offer states exhibit number 1 in attachment.
No objection.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attach.
Yeah. What you see here, or this is the usual. This is day-to-day court. Day-to-day court. And it's a conveyor belt, if you want, of people who either plead guilty, plead not guilty, or continuance, or so what we see here on this channel are when they actually go to trial, usually. And I must say, that is really, really entertaining, very, very educational. This part is equally important in the Western judicial systems. The day-to-day work of a judge who, in my opinion, Judge Stephanie Boyd is a role model. And she apparently loves her job, and she does it well.
And review the same.
No.
All right, we're back on the record in 2024 CR 009739. State, are you proceeding on the indictment as presented?
No, Your Honor, we have a motion to amend the indictment and regarding the Brazos County theft conviction. With the cause number starting with 1-4, we would amend the date of conviction to May 4th, 2015.
All right, any objection?
No, ma'am.
All right, and Ms. Grabs, do you understand that's a substantive change to the indictment?
Yes, ma'am.
And that your attorney would have 10 days to prepare for trial with that change? Did you
Yes, ma'am.
understand?
Yes, ma'am.
All right, do you have any objection to continuing with the plea?
No, ma'am.
All right. Then the court will grant the state's motion without objection and review state's exhibits 1 and attachments for sufficiency.
Yeah. It's no nonsense. Okay, this is it. That's the defendant. Apparently the evidence is there. I don't know the facts. She might have been caught red-handed, so there's not much. I assume it's a she. And okay, I screwed up.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, with regards to the sentencing.
Yes, Judge. Miss, oh, I'm sorry.
Yeah, I will give you 2 choices. One, as previously stated, I found that there was sufficient evidence to find you guilty. I find you guilty. 1, if both parties agree to do GPS as opposed to the 20 days in the Bexar County Jail, what I can tell you, the 20 days in the Bexar County Jail will be less time on GPS. And if I were to do GPS for the court, it's not going to be 40 days. It's going to be 60 days. So if you want to step back and discuss that with your attorney, if you decide to choose the option of Bexar County Jail, I will give you a short time to report, which would be next week would be your report day. So you all can step back and discuss that.
Yes, if I may inquire from the court, if we were to choose the GPS option, Judge, would the court allow my client to have it be partial so she's allowed to work?
Yes.
Okay.
All right, so if you all step back and then let me know your decision.
No nonsense. Everybody knows why they're there. Judge Boyd, yeah, you're guilty of theft. I think that was the charge. You have the option 20 days in jail or 60 days with a GPS monitor in which you will be allowed to work. No nonsense. No fooling around. No. Yeah. So no, she does not waste time. Get them in front of her, make a proper ruling depending on the defendant, and right. No nonsense, fair.
Yeah.
So if you ever, I mean, everybody here loves trials, loves courts, but
I know.
maybe I should do more of these. I don't know yet. I will have a members only stream later this week regarding what's coming next and some changes to this channel. So yeah. So, if you have suggestions, post them in the comment section. Or DM me on it.
My client would like to choose the GPS option. I do have one other request from the court. So on top of, she works full-time at Taco Cabana. On top of that, she is twice per week. She donates plasma, same location. She goes every week. It is part of her income. She counts on that. So if the court would allow her to do that as well as her full-time job, at Tucacabana and then those 2 locations and home.
It gives plasma
All
every
right,
week.
so is she going to be able to afford GPS or no?
No, ma'am. That's why I would like if we could do it through work release, if the court can waive the fees that way.
All right. So you'll have to report then to the Bear County Jail. And you can report the 24th or the 25th.
24th, sooner the better.
All right, 24th is a Monday, so you're able to report then?
Yes, ma'am.
All right. So we're back on the record. This is what the court will do. The court is finding you guilty. The court will sentence you to 60 days. GPS. Waive fees. And it'll be partial GPS for employment and plasma donation. There's to be no contact with HEB. And
Now, she has a full-time job. She gives plasma. I don't know about this defendant's current situation. But for you who know me, hi, I'm Nick. I do labor law. It is my opinion that if you work full-time, you should be able to afford the bare necessities with an apartment, not a lavish, but fitted for your needs. Food on the table, getting to and from work, and then maybe some savings. That is my opinion regarding full-time job, 40 hours a week jobs. Now, I don't know her situation, this defendant, why she felt the need to steal. Maybe she was hungry. I don't know. Maybe I don't know her, but that, in my opinion, full-time job should afford you. Even the, what you call it, the first job. Yeah, but your first job, when I was a kid, with my first job, I could afford my apartment. After a few years, I could afford a house. And I mean, my generation did not, we had so much going back then. And many people don't have that anymore. And so things have changed. But I do believe some of the responsibilities that your first job should make you afford your first apartment. Your first apartment doesn't need luxuries. Over here on this side of the pond, there are regulatory standards of an apartment. It must have a full bathroom. It must have all the things that makes apartments quite expensive. When I had my first apartment, folks, we had a shower in the basement. We had a bath. If you had a larger apartment, you had a bath, a toilet in the in the apartment. If you were like me, a one-room apartment. And when I say one room with kitchen or a kitchenette or whatever you call it. And we had the bathroom, shared toilet at the end of the hall. That was the standard when I was young. And we managed. Just keep it clean. So yeah, that was the standard back in the day. Now, Everything must be so fancy. All right, let's continue.
Do you still have contact with the other co-defendant that's in this case?
That's my wife.
Oh,
All right, state, how do you feel about her having contact with her spouse? Because it appears that you all still together.
Yeah, for 16 years.
yeah, I'm not surprised that she has a wife.
What Sean told me, I believe that her and the co-defendant, or the defendant and co-defendant live together and share children together. And so it's my understanding that they are in a better place at this time. Defendant James Wood is really hot for some time now.
Okay, and what the court will note for the record, it appears that the items that were taken were products that everyone needs to survive.
Yes, ma'am.
All right, so no contact with HEB. And I'm not going to order the $500 fine. And the defendant is to report to the Bear County Jail on February 24th, no later than 11 a.m.
Yes, ma'am.
All right, is there anything else with regards to sentencing?
No, ma'am. Thank you, Judge.
Okay. Did you review the document entitled Trial Courts? I'm so sorry. I need to redo the sentence. The court is finding you guilty. The court is going to sentence you to the Bear County Jail for 40 days, but the court will, I'm sorry, for 20 days, but the court will allow you to serve those 20 days on GPS for 60 days. And I just needed to put that in the record so that it's clear.
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. And one other correction. So it's 20 days in the Bear County Jail under 1244. So with regards to the Trial Court Certification of Defendant's Rights to Appeal, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Good luck to you. You know, I always tell people if there's an issue, there are places where you can go for free that will help you with things. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you so much.
You're welcome. And if you'll make sure that there's nothing she needs from the clerks or the deputy
Yes, ma'am.
for when she turns herself
ma'am.
in.
Judge, I'll report to the court that Mr. Baker settled his case and we'll get you paid.
All right, thank you.
Fair verdict. And it seems like she knows the background of this case and the reason why this person and her wife stole together. And it seems like the underlying issue here is they simply can't afford stuff. So hence the leniency. 20 days in jail, but served with 60 days on an GPS. She's still allowed to work. She can still donate plasma. And she apparently does not have to pay for the GPS. So that is very lenient.
Thank you.
You're welcome.
And she was sentenced to 20 days for being jail, but it's been into 6 days. Yes,
She just. Don't let go. So, thank you.
Yeah. Didn't by, making sure.
He's in by Zoom.
All right, let's see what the next case
He's
is.
joining in by Zoom.
Yeah,
Norman, if you can call him,
the jury has
because I think there may be an issue with his
continued
Zoom.
their deliberations in the Rocky trial. So we are on verdict watch and watching Judge Stephanie Boyd while we wait.
Are you on Zoom already? You connecting? Yeah, just think you might have. Okay. Okay, bye. He's trying to get in, Judge.
All right, thank you.
Hi, Judge.
Hello. All right, the court is calling 2021 CR 9161 State of Texas versus Jennifer Flores. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Alfonso Otero on behalf of the defendant, Judge.
And are you Miss Flores?
Yes.
All right, I do not have I only have the first amended. Does anybody have the original motion to revoke?
Oh, revoke bond. What did you do, Miss Flores?
All right, thank you. All right. Ms. Flores, your attorney is actually appearing by Zoom. Do you have any objections to his appearing by Zoom? All right, you're gonna need to keep your voice up so that the court reporter can hear and so that I can hear. All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
And did you also review the First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes.
Are you the same Jennifer Ann Flores who's placed on deferred adjudication in 2021 CR 9161 for the offense of possession of controlled substance, penalty group 1, 4 to 200 grams on January 26, 2023 for a period of 4 years? Is that you?
Yes.
All right, state.
Judge will be proceeding on the first amended violation of condition number 4 in Bear County, Texas. The defendant, Jennifer Ann Flores, did then and there fail to report to the supervision officer as directed for the months of December 2024 in violation of conviction.
How do you plead to that? True or not true?
True.
And state, do you waive the other allegations? Any objections
No,
to the
no,
state's
pleading.
waivers?
So it was not a.
Oh, I cannot hear you.
No, Judge.
All right. Ms. Flores, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it's for the court to deny the state's motion to continue the defendant for alternative for conditions for status along with after.
Defense, is that what you're asking the court to do?
It is, Judge.
Probation,
Yes, Judge.
what is your recommendation?
Judge, status and remaining custody until treatment bed is available, Judge, and then aftercare. However, the new cases will need to be resolved.
All right, are the new cases going to be resolved?
They are.
All right. Ms. Flores, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Jennifer Flores.
All right, Ms. Flores, you did not report. Why didn't you report?
I didn't report because they had arrested me. So I figured since I violated probation for getting arrested, I was gonna go to court on January 22nd, but I ended up getting arrested on January 22nd. So that's the only reason why I didn't report. I figured I had already MTR'd, so I was gonna go to court and then I knew I was gonna get arrested at court.
All right, so I'm gonna give you options.
Ms. Flores, never assume things. If uncertain and with actual prison time hovering over you, contact your lawyer. Hey, do I still need to report? Yes. Then go report. Now instead, you're in deep trouble, Ms. Flores.
Right?
Okay.
I cannot give a lot of people options. Sometimes I can, sometimes I can't. If you want, what I can do is I will revoke you and I will sentence you to 4 years, or either I will continue you and follow the recommendation for you to be in inpatient treatment. What is the wait time? So your wait time to be placed for treatment is 2 to 6 weeks. So which do you prefer?
I can do the 3 years TDC.
No, 4 years TDC, or these are your two choices: 4 years TDC, or I will follow everyone's agreement and recommendation for probation that you go into inpatient treatment. The wait time for inpatient treatment is 4 to 6 weeks. Now, this is what I can tell you. Regardless of what happens, whether you're waiting 4 to 6 weeks to go into treatment, or whether I sentence you to 4 years prison, time is going to pass. It just depends on what you want to do with that passage of time. Do you want your passage of time where you're just going to prison? Or do you want your passage of time to mean something more? You're getting clean and sober. And here's the thing, you know yourself better than I know you, better than your attorney knows you, or better than the state or probation. This is a choice you have to make for yourself.
I've been, in my line of work, I've been representing addicts, quite many of them, sadly. And what is so dangerous about addiction is I've had clients who don't want treatment. They just want to continue their addiction. Now, this person, I can say as an example, this is many years ago. Over the 3-year period, I got him into 4 treatments. That was to keep his job, he had to go to treatment 4 times over. The 5th time, the company said, if he doesn't go to treatment and actually passes this time for a 1-year period without any incidents, he will be fired. And that guy chose to quit the job instead. And he drank himself to death. I tried to keep contact with him, but less than 2 years after that, after he quit his job, he drank himself to death. He had a provider, enabler, who showed up every morning with a gallon of vodka, cheap vodka. And the next day, that gallon of vodka was empty. He could have had such a productive life, but he chose addiction. He didn't want to stop drinking. He went into these, so at least he could afford. His last few months, he was bedridden. In his own well, he never made it to the bathroom at the end. And he kept drinking and then drank himself to death. So when you look at Miss Flores here, that she actually has to think about what she's going to do, probation and treatment, or 4 years in prison, that's addiction. That's how dangerous it is. I don't know what she will choose here. I haven't seen this. But for some people, they just want to continue. Some people would choose prison over treatment. I believe that is why Judge Boyd gives her these choices, because she knows some people choose prison so they can keep drinking or using drugs.
So whatever you want to do, I'm not going to look at you any differently. You know what I'm going to end up telling you? If you choose to go to prison, you know what I'm going to tell you? When you're released, if you can't find a place to help you maintain your sobriety, you come back here, I'll find a place for you. If you decide to take treatment, guess what I'm going to tell you? If anything happens, let probation know. If you feel they're not addressing it, you can still come back here. So those are your 2 choices. There are no other choices on the table. There's no 3 years on the table. Okay. All right, the court is finding violation of condition number 4 true. The court will deny the motion. Alternate amend conditions. And these are to happen in custody. So there's to be a referral to felony drug court. And also, she's already been approved for SATF.
What's sad here, what you see there, Miss Flores, is, I don't know, early 20s, mid 20s maybe. If the treatment doesn't work in 10 years, she will look her attorney's age. And it's so sad.
All right. So in custody, there's a referral to felony drug court. If she is not accepted in the felony drug court, there's to be SATF, and there's also to be TAP evaluation in custody. And let me see one other thing. And is there a need to extend her or no?
No, Judge.
All right, is there anything else you need from the court to be successful? All right, so off the record, this is what you're gonna be waiting for. You're gonna be in custody. Somebody from probation is gonna come visit you. They're gonna give you a TAP evaluation. TAP evaluation is to figure out what your drug history is. Be honest, because you want to successfully complete this.
Yes.
Then the other evaluation you're going to wait for is felony drug court. Felony drug court is a great program. It's an intensive program, but they'll be able to help you.
Okay.
If you're not eligible or they deem you not suitable for their program, then it's going to be SATF. You understand?
Yes, I understand.
Any questions about anything?
No, thank you. I do have a question. I'm sorry. I just lost my brother on January 29th when I was incarcerated. I just want to know, is there any way that they could help me at least attend the services?
You'll have to speak with probation concerning that.
Okay.
And you know what? Let felony drug court know that. All right. When is his services?
Oh, well, right now they still have the body because he was murdered. So his body's still being held at so under investigation. I'm guessing. That's what my mom told me.
This is
But,
so sad.
So that's all I know right now, that his body's being held. So they haven't pursued yet with dates.
Well, I will tell you what, if you will let probation know when it comes up, I'll see what I can do.
Thank you.
And I'm sorry for your loss.
Thank you.
All right. You're welcome.
Now have a seat. Get on this side.
All right, counsel, you're excused.
Thank you, Judge. Have a good day.
All right, you too.
Oh, this is so sad. Her brother murdered while she was incarcerated. Ah.
No, he's here. Oh, he's here. Oh, go to the side. He's in the back.
Thank you.
Down to the meeting.
Jones? Kevin Jones?
Yeah, this is the day-to-day court where you see and hear about
Yes.
tragic events.
An off-docket matter.
Okay.
Mr. Jones has come to the court with some concerns. He's on GPS monitor and he would like to see about getting his monitor times adjusted.
All right. So what times are you requesting?
Well, for right now, I have a newborn child.
Okay. Congratulations.
Yes, ma'am.
Let's make sure we are giving them the best example that we can. All right.
So I was supposed to be at the hospital and I didn't think I was gonna be here this long, but at 2:30, I have to, the baby's ready to be discharged.
Okay.
And I have to be there. They don't want me to come in and out from the baby feeding this day, that day. They're gonna do it all in several hours.
All right. Any objections to him with the baby at the hospital?
No, Judge, I think there's just other stuff that might be needs to be addressed, and I'll let him explain it.
Okay. So there's no objections to you being at the hospital. Are they still waiting to release the baby? Or have they already left?
No, we there to do the baby feeding and the CPR class.
Oh, you got to do the CPR classes.
Yes.
You know, back in the day, they didn't give you CPR classes. They just said, good luck to you and your baby. Yeah. All right.
I'm a full-time student at a South Texas Vocational Technical Institute.
Okay.
I go to school from 8 a.m. to 1 p.m.
8 a.m. to 1 p.m. That school.
I'm currently looking for a job.
All right. So 8 a.m. to 1 p.m. school. What days?
Monday through Friday.
Monday through Friday. Okay. And then you have the baby hospital. So there's going to be no issues with you at the hospital. Okay. And there's no issues with school. I think everybody wants you to.
Okay, we will listen to this and then we have this morning's hearing. The video is up since a few minutes, but I want to hear what happens here first.
Better yourself. All right. So what's the other issue?
Maybe besides setting up appointments for the baby, looking for a job, there's nothing else really.
All right. So State, let me ask you, is this something maybe tracking with curfew?
Well, Judge, I think, I don't know if it's been said, but my understanding is that the mother of the child is not present,
Mhm.
and that's a concern, because I don't know who's taking care of the child when she's not around and he's not around.
Okay.
So that's just a concern of the state. I think that since it's really called.
All right. Who's taking care of the baby when you're not around? I'm sorry? Oh, isn't it always grandmothers being parents? All right. So he's saying his mom. Any other concerns?
Not necessarily, Judge. I just to let the court know, I did email the school where he's taking, I believe, combination welding classes at, confirmed that he was attending from Monday through Friday, 8 a.m. to 1 p.m.
Okay.
That's what the coordinator said. And the only concerns are just to make sure that the newborn child is taken care of. That's the other concern of the state.
All right. Let me ask you this with regards to the newborn. So when you're not around and the mother is not around, you say that your mom is the person who takes care of the child? All right.
Yeah, so.
Wait a minute. You're just about to say something important and the machine is printing. Okay. Yes.
Daycare services, if it's needed.
All right, please check into daycare services. Just don't take your baby to anybody's daycare. You know, people need to start investigating daycares when you're taking your child there. I always would tell clients that I would have, would you just go to a strange house, not knowing anybody, and you just are in there, or would you want to investigate what's going on? So make sure that you investigate the daycare, because your baby is not at the age, I believe, where they can talk and tell you what's going on, right? So investigate, just don't drop your child off someplace, okay? All righty, so is there an issue with tracking, or do y'all want to, what I can do is I can try out this schedule, allowing him to go to school full time, be with his child and see how that goes. And then maybe move towards tracking only.
Judge, yeah, I mean, the state's been okay with it. It seems like he at least is trying to excel and going to school and being a responsible father. The concern was that the mother wasn't, I guess, present or not able to be present because of possibility incarceration. And so that was this concern of the state, and it's just brought to preservation.
All right, so let me ask you this. Have you had a chance to talk to his mom?
She said she apologized. She's looking for parking.
Oh, she's driving around?
She's trying to find parking.
Oh, let me ask you, can she zoom in? Does she know how to zoom? I'm driving.
Judge, and I did tell the state that in regards to his concerns, there are field visits that are already a part of his condition terms to where our officers will be doing home visits.
Okay, and then what I can say, and as a part of the conditions that I added, was that he's to reside with his mom. So you're residing with your mom? So. All right, then, do you want to do tracking only, and then we can do an update?
That'd be fine.
All right, so what I'm going to do is I'm going to do tracking only. What that means is, really, don't go wild, right? Just do your school, taking care of your child, looking for employment. Don't get sidetracked, because it's easy to get off that path, okay?
Even before I got to put on Friday, I've been at home and just going to school. I ain't been trying to get no trouble.
All right, well, I'm so proud that you're actually bettering yourself. Welding is a good profession. Don't burn yourself too much. Well, you know what they say? They say you're not.
Yeah. Welding. A good welder can make bank. Taking all the certificates, you can make serious money. I'm happy for this guy, turning his life around, going to school, learning to weld. Yeah. Good on you, kid. Good on you, kid. Good on you. Did they say where baby mama is? Yeah, she is currently looking for parking, so she's driving around looking for parking. Good on you, kid.
Not a welder until you're burned. And then I knew an attorney who decided he was going to be a carpenter. He's a carpenter, but he lost a digit. And he said, people say you're not a carpenter until you've lost a digit. As people say, you're not an attorney till you've had a grievance filed against you. There's so many professions like that. All right, so what I'm going to do is I'm going to do tracking only.
Oh,
And does he have community service hours?
I do.
All right, so Bashan,
That's good.
he has the community service hours, but I did put down he completes parenting classes and his community service hours will be deemed satisfied. So do the CPR classes, do parenting classes, and then you won't have to do the community service hours. All right, so they'll be tracking only, and then we will recall this for, you all want to recall this in 30 days or 60 days to see how things are going?
Either.
All right. Norma, we're going to recall this. It's 2023 CR 5280. We'll recall this. What's a good time for you to come down? What day of the week? Okay, so any day in the afternoon, we could set it at 2. Get out one. You want to do 2:30?
Yes.
All right, and then I understand if you're driving from school. So we can set at April 7th, 8th, or 10th. So that's Monday, Tuesday, or Thursday. All right, all right, so we'll do Tuesday then. No, usually that's our jury trial day. We'll do it Monday the 7th, okay? And I'll put you down April 7th at 2 p.m. I'm saying 2 p.m., but I'll write on the docket sheet 2-ish because sometimes traffic is some kind of way. Well, congratulations. I'm glad you're doing well. Keep it up, okay? All right, thank you. Yes, Norma, can you give him a reset form and put 2-ish on there, please?
I'm glad we finished listening to this. This is a good story. A kid who is turning his life around. That is, yeah. But now, this morning, sanctions hearing and a wild Lewin making a complete ass of himself. This will be interesting. Oh, no subtitles. Oh, we'll have to survive. All right, let's go. Why is it no sound? There's no sound. Oh.
Yeah,
There we go.
The jury's over there, so they gotta keep us awake.
All right. You ready, Kevin?
Ready.
What? What the frick is going on now? Can you hear anything, chat? Because I can't hear anything.
That was not inadvertent, and that did not occur.
We had regarding the question that you are asking about right now. In that regard, I can't
here we
really
go.
speak to anything the judge said at the sidebar during Relly's testimony. I do not believe that that is a violation of the gag order. That's the ruling. I don't need any response from anybody else, from anybody. All right, the motion filed by the defense. I've read the motion. Mr. Lewin, did you want to respond?
The motion's absurd. It's being done clearly, as was the interview, to attempt to sway the jury. It's interesting that after telling the court repeatedly and counsel on the record that he would not be doing any interviews during the pendency of this trial, that the day before the jury deliberates, he does.
No. I'm done with that.
I'm explaining the motion. The motion, number one, sets out two apparently issues. One is that he is trying to say that I intentionally switched photographs. Now I'm going to show them up to the court. It's patently absurd. Just so it's clear, I got in this case extremely late. I was on the case basically.
Okay, this is what he did during closing arguments. Another thing, he brought two pictures up to, a few items to show the jury during his closing argument. And this asswipe brought with him a photo that was excluded by the court. That is not a mistake. You twat. That's not a mistake. You knew that you were only allowed to have one picture of the scraped knuckles. And you chose one photo of the scraped knuckles. Why did you even bring the other photo if you knew no more photos? One is enough. Because you're a twat.
Started the day before trial. So I had the exhibits from my co-counsel. The exhibit list that I had, he had a number of photos of the victim's fingers, the injury that he had. The exhibit that I had and that I used in closing, although it was on his exhibit list that he gave me, it's not the photo that he used. But just so it's clear, Mr. President.
You're blaming co-counsel, you coward. You have responsibility of knowing what you bring up to the table. And now you're whining, oh, my co-counsel's exhibit list. You're one and the same. You are the state. You have a responsibility of knowing. You absolute twat.
Just so it's clear, both photos, this is the correct exhibit, as the court is aware, and this exhibit basically shows the injury to the finger. This is People's 17. I used a photo which also shows his hand with the injuries, thinking that was the exhibit that was used. As the court is aware, does the court need me to come up to the court to examine them or not?
No.
They're showing the same thing. There's absolutely no prejudice. It's absurd.
And I know that's correct.
Yes. Regarding the second issue, let me be clear about this. We admitted People's 15. I had no part in gathering those videos. I got them from my co-counsel. Both parties, both the defense and the people, slowed down their respective exhibits during closing argument. I said on the record, I am playing this at half speed. When you slow down a video, it slows down how it is played. It does not change how the video is presented. But I want to add something else. Both Mr. Przemyk and I have been extremely clear from the start. It is not when the particular gunshot was fired. What is important is, and this is demonstrated on the video, is that the cause of the incident was not the victim attacking ASAP Ills. It was the defendant pulling out his firearm. That is what prompts, when he pulls out the firearm, that is what prompts the victim to try to hide behind Ills. So the idea that somehow I slowed down or changed the video is absurd.
This is not absurd. Whining little bitch ass. This is so infuriating to say, I didn't do, and then his moron face. I didn't slow down the video. You manipulated the sound of a video in order to make it look like the gunshot came sooner. That's not a mistake, you asshole.
I didn't even have the capability to do it. What I did is exactly what I said. I played it at a reduced speed, which, by the way, before I did my argument, counsel got up on the other side and he said, I'm going to play this at slow speed, his exhibit. Now, if we go back one step, the defense had an issue apparently with the surveillance videos that Mr. Kroslemek gave them well in advance of this case. After the conclusion of our case, and actually at the end of their case, they actually moved the court, if the court can recall, because they wanted to put in a different video. The court allowed that video in. That video is evidence, our video is evidence. I would finally add that what is said in closing argument is not evidence in the case. What is said in closing argument is argument. The exhibits speak for themselves. And finally, because it needs to be addressed, counsel is apparently in discussions with a couple of lawyers on 2 murder cases, which I won, where that appellate lawyer is involved in both of them. And he has basically attempted to tarnish my well-deserved 30-year reputation, which the court has commented on repeatedly. There has only been one time in this case where a court has found that there was any violation that was not inadvertent, and that did not occur with the people. So let's be clear. When they put in their motion, and there's no reason for it, Your Honor, they quote a Ninth Circuit opinion, which, by the way, was reversed, not for prosecutorial misconduct, it was reversed for instructional error.
They still wrote in that you are a lying sack of shit. This is the Ninth Circuit order. Reversal. No, it wasn't for prosecutorial misconduct, but they still took the time to write into their opinion that you are a lying sack of shit. Jesus Christ, what a crybaby.
But I'm just going to add that Justice Hofstede, who is one of the most outstanding justices in the California court system, wrote the original opinion, found no error whatsoever. Neither did the Cal Supreme Court. Neither did the federal district court judge who looked at the case. And I will just add that in the very Ninth Circuit opinion that they cite, which was a 2-to-1 decision, if you go to the dissent makes clear in their dissent that, in fact, my argument about Joe Giarrusso and the fact that the victim in that case was alone at the time of the murder,
that was not your claim in court, you lying sack of shit. You claimed the victim was alone the entire evening, which was a lie. So what he is doing here, folks, he is now claiming that the majority decision and its opinion is false. He's calling 2 Ninth Circuit judges liars in open court.
Majority felt that because she had had dinner with him hours before the murder, that meant she was not alone that night. As the dissent made clear, and as the California Court of Appeal made clear, I was commenting on the fact that at the time she was murdered in the middle of the night, almost beheaded, she was by herself. Now, why that has any business in a motion they filed, you would have to ask them. But I find it
is your pattern of dishonesty, Lewin. A clear pattern of lying in court.
extremely interesting that given the repeated discovery violations, which the court has found, given the leaks to the media, which, by the way, the individual who did the interview yesterday, who is apparently Mr. Tacopina's close friend and law school education partner, she is the one who reported an alleged conversation that originally occurred at sidebar. I find it rich that the defense makes these allegations.
Oh, he's friends with the. You see how he keeps going? Oh, it's not his fault. They are friends, so they do that. He's in less than 6 minutes. This piece of junk blames his co-counsel, then blames the defense, and then he calls 2 Ninth Circuit judges liars. This is amazing. How can you be this much of an asshole and still not be homeless?
They are slanderous. They are not accurate. And I've got a 30-year reputation with this court and with my office, which I will stand by. And the minute the court.
You have been a whining little bitch for 30 years, and somehow you manage to get convictions once in a while.
Finds that I've done anything unethical, I would like the court to say so. I'm going to add one last thing because it's important. The defense was upset because we ended up getting a report from ballistics that was inculpatory. It only would have helped us. As soon as we got it, we turned it over to them. We then made arrangements to get them the evidence. And in fact, we didn't end up.
How can a ballistic report on fake shell casing help you? I can't believe this. I can't believe how he can sit there as an attorney with a law degree, passing the bar, and lie this effortless. Make accusations this effortless. Now you got, folks, now you might understand my disdain for this garbage. He is misrepresenting what the Ninth Circuit Court actually found. He's trying to lie himself out of him and Raleigh are from the same mold. Habitual liars.
Up doing testing at the court's order because of the timing. The defense was actually given more ability to test the evidence than we were just because of the timing involved. The court found at the time that as soon as we were aware of information, we turned it over. The court is also aware of a second situation, which has not been made public, where we became aware of potential evidence, didn't know whether it would be exculpatory or inculpatory, and we alerted the court to that, and the court ended up making arrangements. Every single issue that we've had in this case regarding discovery, as soon as we find it, we present it to the defense. Finally, the issue with the alleged stipulation with Raleigh. As the court is aware, and as the court has stated on the record, everybody at the time believed that the stipulation, that the firing range was out of state. That was my understanding when it happened. As the court is aware, numerous times during this case, I offered to stipulate to assist the defense. Many times, as the court is aware, Mr. Tacopino would be standing up there, not knowing what his problem was, not knowing what the foundation was, not knowing how to introduce certain evidence. And I would say to him, he would look at me, what's wrong? And I would say, okay, Joe, here's what I can do. And I would stipulate. I made that offer to stipulate because everybody at the time believed that the firing range was in California. The court has already found that the court believed it. We believed it. That's why we offered it. I would further add that the fact that the victim was in California at a firing range 2 weeks before this incident occurred has about almost no relevance or impact on the case. However, when aspersions are made that somehow that was kept from them or that somehow we ended up asking for a stipulation in anything other than good faith, the court has already made its comments. I would request the court to I'm asking the court, if the court thinks that anything that Mr. Proslenik and I have done has been a violation of discovery, has been unethical, I'd like the court to say so. The court has been very clear that that is not the court's belief. In the end, we made a conscious decision because it's ethical not to try this case in the press. You haven't seen one comment from us, not one. Mr. Tacopina's motion, or maybe it's motion, I don't know what communication, has insinuated that somehow we're talking to a reporter. We know he's talking to a reporter. Let's back it up. I am more than willing right now to go under oath.
No, we're not doing that.
Well,
We're not doing that.
Well, understood, Your Honor, but I want to make sure that my personal integrity has been impugned. I won't stand for it. I am more than happy. You put me under oath, you put Mr. Tacopina. I understand the court doesn't want to do it, but I want to make sure I've offered that, haven't heard the same thing from Mr. Tacopina. Would love for that to occur.
Who wants to speak?
I'll speak, Your Honor, to this. Okay, because all I've been hearing for the last 10 minutes is deflection here. So Mr. Lewin just asked. Deflection. All he's doing is deflecting. So first of all, he asked, why we would raise a Ninth Circuit decision. What does it have to do with this? Someone should ask us. Okay, the question's been asked. Here's what it has to do with this. The Ninth Circuit said that Mr. Lewin lied to a jury. That's why. Here he is saying, "Oh, my reputation."
That is untrue.
I let him speak, Your Honor.
Don't interrupt.
Your Honor, I'm not going to have that kind of personal aspersion made against my reputation.
Shut the
character.
fuck
I won't have
up,
it.
you whiny little bitch.
I didn't say it. They said it.
The Ninth Circuit did not say that.
Your Honor, the Ninth Circuit said there was an untruth that was presented to the jury by this individual right here, regardless of the basis for reversal. That's what the Ninth Circuit said. And the reason we raised it with respect to this is because there's a claim of prosecutorial misconduct. And by the way, let's deal with this in reverse. The stipulation, right? Because that was one issue of prosecutorial misconduct. I just heard Mr. Lewin say that everyone believed that shooting range was out of state. Who believed that? The witness didn't know that. Mr. Tacopina didn't know that. In fact, did Mr. Lewin know that it was out of state? Did he? Because I find that very difficult to believe, given the fact that it was not out of state. So either one of two things happened, and Mr. Tacopina said this previously. Either one, he knew it wasn't out of state and tried to lie to the jury, or best case scenario for Mr. Lewin, he didn't know and asked for a stipulation. Now, on this point, let me just...
The stipulation they are talking about here is when Relly said the gun range was definitely not in Los Angeles. And they agreed to this stipulation. And this stipulation was based on false facts. Relly was in Los Angeles. And I don't think... the only reason Lewin might not have known about this is because he didn't care to investigate. So that's the only reason, because he is incompetent, or he is dishonest and don't want to investigate because he's scared of what it might result. And this time it resulted in him making a false claim in a stipulation. They believed him when he said, wasn't in LA. And as it turns out, it was in LA. That is prosecutorial misconduct.
Just know, I know that Mr. Lewin apparently...
Slow down.
Fine, fair enough. I know that Mr. Lewin...
Slow down.
I know, Your Honor, that Mr. Lewin, because he's represented this to other people, is, my understanding, knowledgeable about firearms. He carries them. I find it very difficult to believe that Mr. Lewin did not know that the LA shooting range is not in Los Angeles. So when he's here trying to bolster his own reputation...
I'm going to ask the counsel to not bring up anything personal about what I do or do not do when I'm outside of the office. It is absolutely inappropriate.
That's fair.
Well, Your Honor, when this individual, Mr. Lewin...
Just talk about your motion. That's what I want you to talk about.
Well, okay, Your Honor. I definitely want to.
All 11 pages.
Thank you very much,
Stick to
Your Honor.
that.
Fine. The claim here is one of prosecutorial misconduct, and specifically deliberate prosecutorial misconduct, which is why I was raising these other issues and just responding to Mr. Lewin. With that said, let me focus on the motion. So we didn't raise this issue to distract or try to mislead the jury. To the contrary, the misleading was done by the prosecution. The court will recall, at the end of Friday's proceedings, we raised this issue with the court and said it appeared to us, looking at the video on the screen, that it was altered. We then asked Mr. Lewin, would you show us the PowerPoint so we could resolve this issue now and avoid potential appellate issues? You would think at a bare minimum, to avoid this very matter, he would have said, sure, take a look at it. Instead, no, he adamantly refused, packed his bags, and got out of that courtroom as fast as anyone could. Now, we then
Lewin knew. He just didn't think he would get caught. Remember the video in closing arguments where he slowed down and made it seem like the gunshot came before the fight? That is, and then just show us. And then he just, like a little coward, packed his bag and bolted out of there. Textbook prosecutorial misconduct.
fortunately had the opportunity to look at that video because it was televised on court TV. And sure enough, it was altered. That wasn't People's Exhibit 15, okay? What the video that Mr. Lewin presented to this jury during summation showed was the shot taking place before Relly ran towards Ills. Now, the prosecution says, oh, it's not a significant issue. The timing of the shot couldn't be more significant with respect to the claim of self-defense. Now, perhaps Mr. Lewin doesn't realize that it's an issue in this case when he and the prosecution in general told the jury they only have one matter to consider, which is a prop gun. That's not the case. Self-defense, of course, is an issue in this matter if the jury finds that there was no prop gun. The timing of this couldn't be more critical. So, Your Honor, this has nothing to do with slowing down a tape. That's what Mr. Lewin speaks to. Oh, we slowed down the video. It's not about that. It's about moving the shot a second earlier. That's what they did. And I would just add, People's Exhibit 15, and we raised an issue with this previously. We were advised by the prosecution that Detective Flores is the one who prepared that video. When Mr. Tacopina questioned Detective Flores about it, he said, no, it wasn't me. Even at this moment, we don't know who prepared People's Exhibit 15. There wasn't a proper foundation laid for it. We objected. The court allowed it in. But now, during summation, to alter that video further and present a misleading image to the jury in terms of what happened couldn't be more of an example of prosecutorial misconduct in this case. The law is clear. And in that regard, I would note this. I don't accept Mr. Lewin's assertion. I know the court has spoken to this, but I don't accept Mr. Lewin's assertion that the photograph of the quote-unquote bloody knuckles that was introduced was inadvertent. I see him holding a photograph right now. I can assure you that the photograph that was displayed to the jury was not what he had in his hands. It was brighter. It exaggerated the nature of the injury. Unfortunately, they had the weekend to do whatever it is that they did with their videos and with their photographs. But the fact of the matter is we all saw it. There was a photograph that was introduced to this jury that was not admitted, that exaggerated the extent of purportedly the complainant's knuckles. We don't know because there was no testimony regarding that. Never should have been presented. I appreciate the court swiftly taking action to resolve that situation. But given that that occurred once, and now we have another video that alters what occurred, I find it difficult to believe.
You want to see the picture he actually showed instead of the exhibit he should have shown? I hope I can get Hella to take a look at this because this looks enhanced. This is not even close to the exhibit that was allowed in by this judge. It's not even close. This is, this is not even a fresh scrape knuckles looks like that. That to, I'm not a Photoshop guy, but that looks enhanced to me. And it is this guy on the left, right on top of me here, smiling. He cheats. In order to get a win, this cunt alters evidence. Yeah, and as Crystal says, that's not a day old. Remember, the testimony was he didn't photograph it until the next day. It's so insanely stupid.
That it was inadvertent. And in fact, for that matter, how? How could you have a video inadvertently manipulated? It's deliberate action. So, Your Honor, here's where we are. There was a video that misleadingly presented to the jury something that was not People's Exhibit 15. The only resolution at this point, Your Honor, would be to advise the jury to disregard that video that was presented by the people because it moved the shot to an earlier time than what's reflected on People's Exhibit 15. That's the only solution at this point, to try to resolve this issue and avoid potential appellate issues. That's our request. We briefed the issue, the law is clear. You know, I don't know what more to do at this point, but it has to be addressed to this jury because right now they're in the back.
No, they're not. Not yet.
They will be, fair enough, Your Honor. They will be in the back, having seen the last video in the courtroom, one that wasn't in evidence and misrepresents the timing of the shot. It couldn't be more paramount despite the prosecution's claims that it's insignificant. I know they want it to be insignificant, but it couldn't be more significant with respect to the issue of self-defense, Your Honor.
Your Honor, can I just respond to the video portion of it? I don't need to yell and I don't need to hash out anything else. But as to the surveillance video, all that happened, it took some technical expertise to create that video where one is on top of another, which is not any kind of program that I have access to. So I went to someone in the DA's office who works in our video laboratory.
If you did that, you have a responsibility to bring it to the court's attention that you have made a new video where you put things on top of each other to present it as this is a mix of these two that we want to see, that we want to show the jury. Then the defense has to look at it and the judge make a ruling. What you did instead, you absolute fucktwats, was hiding it from the court, hiding it from the defense, that you altered video evidence.
That has access to Adobe Premiere and asked her to line up those two videos at the point in time when the
this is evidence tampering.
When a floodlight is seen in both videos as a visual cue. And if the court is not following what I'm saying, I can pull up the video and show the court. And that was done with Detective Flores's, kind of in pre-consult with him. He was aware of what was going to happen. We talked about how that was going to.
Tell me again. You went to someone in the DA's office and they did what?
Just ask them to put the videos on top of each other because one video has audio and one captures actually captured the shooting. Okay, so it's the video that we've all been describing as sequenced surveillance video. It just took a special program called Adobe Premiere to be able to play those two videos at the same time and screen record. That was it. That happened well before the trial, and I gave that to defense counsel, and I told them that Detective Flores would authenticate the video, not that he had been the one who created it with computer programs. So that was all that happened with how that video was created, and I had asked her to line it up with a visual cue in the videos, which is when a floodlight turns on. That video has not been changed, manipulated, or anything since the trial happened. I have not gone back to the person who created that video or anything like that. So I can tell you, and honestly, and this is more from my personal experiences with Mr. Lewin and his technical abilities, I can guarantee you Mr. Lewin would not have the ability to move the sound of the gunshot in those videos. I mean.
And yet it was moved. And it doesn't matter if he personally is, besides being a fucktwat in real life, a buffoon as a prosecutor and technically incompetent, it's the state. You are all one. You are all one. What one does, all does. You are the government's representative in that courtroom. It doesn't matter. One did that, one did that. Oh, somebody else fucked up. No, the prosecution fucked up. And they should be held accountable for it.
So to that issue on whether or not the video that he played for the jury was changed, I can tell you that's the only copy of that video that we've had where the two videos are playing on top of each other. There's only one that exists. It's been labeled sequence surveillance video. It's the one that was played in his PowerPoint. I can't speak to how it came out on court TV, but I can tell you we did not move the sound of that shot, and nor do we, I think as Mr. Lewin articulated, feel that that is really the relevant inquiry for the jury. We have always argued, I did it in mine and he did it in his closing, that the point in time that matters is when the defendant turns around having pulled the gun, not when he actually fires it. So I just wanted to add that because Mr. Siegel had brought up how the video was created and that we had changed it. That video was not changed as it went into Mr. Lewin's power.
Your Honor, if
No,
I could just read this
I've heard enough.
Your Honor.
You filed the motion, I heard from Mr. Lewin, I heard from you,
Right.
and then I heard from Mr. Kuzlowski. That's it. No more. That's it. All right, based on the explanation from Mr. Kuzlowski, I can say I don't believe anything nefarious occurred.
Oh,
here.
for fuck's sake. You weakling. You weakling. That has been your excuse this entire trial. Time and time and time and time again. Misconduct after misconduct after. Oh, I don't think he meant it. Oh, it's nothing nefarious. I don't think you believe this yourself, Your Honor. You're protecting the prosecutor here.
I don't think anything was altered. Now,
it's provably altered. They just told you how they did. They took one video and put it on top of each other. That's not Exhibit 15. That it's manufactured. You don't think anything was altered? It is provably altered because it's not the same as Exhibit 15. This is so stupid.
what the focus is, or what the issue is with the defense has to do with People's 15, which is the video that was admitted into evidence, and the PowerPoint. People's 15, which the jury has, shows from the time elapsed from the second shot to Rocky coming in contact with 12E is 6.98 seconds. The PowerPoint, which Mr. Kuzlowski described as trying to put one on top of the other, the sound in addition to the video, the audio on top of the video. That shows that there is 7.98 seconds that elapsed between the second shot to Rocky coming in contact with 12E. Do you really think, does anybody really think that by showing that video to the jury in final argument, that they would pick up that there was a 1 second difference?
Yes. 1 second is a lot. Let me demonstrate, you twat. Three, 2, 1, boom. 3, 2, boom. Of course, a 1 second. Your Honor, I've been in the military. You know what can happen in 1 second? A person charging at you are going from a safe distance, making me available to pick up my gun and return the. If I wait 1 second, I may not have the time. Yes, 1 second is a lot, especially if it's Exhibit 15 already admitted into evidence. And they altered it. You might not think that 1 second is important. That's not the issue here. The issue here is that they altered the timing. I can't believe this.
Between the PowerPoint and People's 15, that is virtually impossible. No human would be able to do that. In addition, what is
Your Honor, you don't have the capability to make that judgment. When you say no human has the ability, you are making a claim that out of, how many are we now? Let's say, out of 300 million Americans, not one of them can see that there is a 1 second difference. That is your claim. That
said in final argument and in summation is fair comment. It is not evidence. The jury was told that. As to the hand photo, I don't agree with you, Mr. Siegel. I think it was done by accident. The two photos are almost identical, and it was corrected immediately. The defendant's motion for an order directing the people to preserve its closing argument PowerPoint with regard to prosecutorial misconduct is denied. The motion to request that the court instruct the jury to disregard the sequence surveillance video displayed during the Mr. Lewin's summation argument is denied. All right, that's it.
Your Honor,
No,
just
no.
for the record, I need to make a record on that day. We're not quarreling with your decision, Your Honor. We accept it, we understand it.
All right.
Notwithstanding
Say
our
what you
objection.
want to say for.
Thank you very much. Just quickly, because this is the first time that we've heard an explanation from the prosecution regarding specifically how People's Exhibit 15 was
All right,
made.
say what you want to say.
Thank you very much, Your Honor. So there's been no witness, Detective Flores certainly didn't do it, to authenticate People's Exhibit 15. I don't know who this person was in their office that they just described that made it, but there's been no evidence to lay a proper foundation. In light of that fact, Your Honor, we're asking you to exclude People's Exhibit 15.
All right.
This will be a huge appellate issue, in my opinion. Now they can claim, oh, it's what they say is not evidence. No, but the problem here is not what they said. It was they showed an evidence they claimed was evidence presented in trial. Let's see here. Jury has reached a verdict, will be read in 90 minutes. So, oh God, it's midnight here and I have a work day tomorrow, but I will not miss this. 90 minutes. Yeah, screw sleep. Let's see here, hold on. let's listen to the final piece of yeah.
If we hear from the jury, we will let you all know.
And the judge denied everything.
An hour.
The things, in my opinion,
I think you
is
said
near
I think you said
appellate.
90 minutes, Your Honor. You would agree to 90 minutes?
No, if there is any communication, will you all be available by phone?
I will be, absolutely. I won't be personally potentially here.
All right, so the only reason you have to come in is if there's a verdict or if the jury indicates that they are at impasse.
Well, Your Honor, what about if there's a note requesting a readback and we have to sort of,
We call you.
yeah, and then how do
And
we?
we'll talk about it. Usually, when a jury requests readback, they'll say, okay, we want witness Jones's testimony about X.
Okay.
What I do and what Kathy does is we find out what the witness said about X on direct, cross, redirect, recross. Anything the witness said about X is provided. But nothing more.
Okay.
And nothing less.
Do we weigh in on that at all?
Well, of course.
Okay, so how, if we're not here physically, how do we do that?
You do it
We have a
on a speakerphone.
Oh, okay.
Alex knows how to do it.
So we, okay, so someone knows how to do it. So we don't have to be here to discuss
No.
the notes?
No.
That's the same with questions. If there's a question, they'll read us the question.
Okay.
We'll amongst ourselves.
Alex will take a photo of it and send it to you.
If we agree on an answer, then we end up talking to the court by phone or by WebEx and they do it.
Okay, so
Generally,
we're
do not have to be in here.
Alex takes a photo of it and sends it to you.
Okay.
The actual written question.
Good.
All right.
Your Honor, can I add one thing, which is we provided a clean laptop to Alex for the jurors' use. If the defense wants to go through it, I gave it to Alex. They can do whatever they want.
Thanks, Bob.
There is, if you want to go in and take a look, there's a computer with a projector and a screen.
Could we do that? There's no
Yeah,
conference.
go take a look.
Their notes are back there and things.
What?
The jurors' notes and stuff are back there.
Oh.
The jurors.
Could Alex walk in with us? Just
Yeah, they have it, yes. Just go take a look.
Okay.
All right. Okay, will be read at 4 p.m. It says here on Law and Crim. So that is in another hour. So, yeah, in an hour, we will learn and of course, people over on social media are claiming, oh, it's this verdict, or it's that verdict. None of that is true. We only know that the jury has reached a verdict. We do not know what it is yet. Hi, JT. Good to see you. Good to see you. And So 3 hours roughly. Yeah. Yeah, so you can see it. 4 hours it took them to reach a verdict. So that, yeah, 9 p. Oh, no, not 9 p.m. Eastern Standard Time, or is it? What time is it in LA now? It is 3 p.m. So in an hour. In an hour, the verdict will be read in court. So what are we going to spend an hour with? So 6 p.m. Eastern Standard Time, or 7 p.m. in an hour. In an hour. Let's get back to Judge Stephanie Boyd. So 4 p.m. Pacific Time. In an hour. So let's spend an hour listening to Judge Stephanie Boyd. I will have, as you know, this will be in the background, so I will hear it. So let's listen to Stephanie Boyd for an hour.
You said 2:30, Judge? Yeah, well, 2-ish. So you can put it down for 2, and I'll understand if he's a little late. And Kevin, Mr. Jones, make sure you call the hospital to tell them that you're on your way. Okay.
Okay, now I'm getting nervous. We will all know in an hour.
All right, Deputy, could one of you make the announcement for Jose Ricardo Maciel?
Did you receive my text message on that?
Yes.
Can you put that correct there? Thank you, Matt.
And Norma, in that case, was there a reset form or was the attorney to let him know?
No, there was a reset form.
Okay. All right, court is calling 2024 CR 011828 State versus Jose Ricardo Maciel. Could I have somebody from the state? All right, Deputy Laura, did you make an announcement for Mr. Jose Maciel?
Yes, Your Honor, I did. He is not out there.
All right, this hearing was scheduled at 9 a.m. It is now 3:24 p.m. The defendant has not made an appearance. State? Now, do you see defense counsel here? They're not present. So what are you requesting, State? All right, thank you. You may be excused. All right, Deputy, I'm sorry. Norma?
Yes.
Is this a PR bond?
Let me.
It appears to be a commercial bond.
Apologies, Judge, I didn't have it up there. AAA bill bonds.
All right, and Coordinator Ferguson?
Yes.
Was there a reset form that was signed by the defendant and the defense attorney?
Let me see if it's there, Judge. I know it's hard now, for sure.
The scan may be on my desk, Judge. I apologize if it's go behind my scans. You need me to locate it?
Yes, I just need to know if it was signed by both the defense and the defendant and defense attorney. Okay, no, the changes. All right, I'll take care of it.
I've been asked a lot, what do I think will happen?
Thank you.
What do I think?
We're still on the record. All right, the court is in receipt of a case setting form that was,
I don't know. It should be a clear not guilty due to prosecutorial misconduct, investigators being absolutely so bad, it's ridiculous. But I've also seen trials with less evidence get a guilty verdict. So I honestly, I don't know. I don't know.
from February 11th, 2025. And it has a reset date on it of February 18th, 2025 for 9 a.m. The defendant has signed the document and so has the defense attorney. The court will issue a bond forfeiture, remand the defendant without bond. If the defendant makes an appearance, the court will reconsider. All right, is the interpreter here on Edgar Aguilar? Right, the court is calling 2023 CR 4709 State versus Edgar Aguilar. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense.
Megan Enriquez and Don Coons for Edgar Aguilar.
And are you Edgar Aguilar?
Yes.
All right, we have an interpreter here. Could you raise your right hand? Do you solemnly swear affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God? All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Sáez.
All right, so we're here for sentencing today. The jury rendered their verdict, and in count one, the jury found you not guilty of aggravated assault with a deadly weapon. They did find you guilty of the lesser included offense of assault. In count two, you were found guilty of aggravated assault with a deadly weapon. And in count three, you were found guilty of aggravated assault with a deadly weapon. We are here today for sentencing. State, do you have any witnesses?
Yes, Judge.
All right, do you all need to sit down for this or no?
No.
All right. All right, Lopez, please.
Aguilar.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Victor Lopez.
All right, state.
Mr. Lopez, are you a resident of Bear County?
Yes, I am.
How long have you lived in Bear County?
About 34 years.
Okay, and are you currently employed?
Yes,
What type of line of work do you do?
I do HVAC and maintenance.
And I know you know that you're here regarding an incident that occurred on March 16th, 2023, correct?
Yes.
Okay. Do you recall what you were doing that day?
We're coming from the main office that I used to work for, going to another apartment to go work already.
Okay, and when you say leave, Who you're referring to?
Yeah, my friend Augustine, he was my coworker and we became friends.
And what kind of car were you driving?
We were driving a black Explorer.
Okay, and do you recall what highway you were traveling on?
We'll go 410.
And what direction were you going? Towards the airport or not?
Towards the airport. We're going towards the airport.
Okay. You were driving with cars and vehicle acting out of the ordinary.
Yes, I was on the far right lane and on the access road to come into the highway. I noticed it. The reason I noticed is because Augustine says he told me what's wrong with this truck. I looked and this truck was trying to hit us, trying to get me off the road.
Do you recall what the truck looked like?
Yes, it was a Dodge Ram, beige.
Okay. And when this is occurring, were you able to observe the driver?
Yes, he looked at me. We looked at each other, and he was throwing up his hands and like cussing me out. And I was like, I don't even know the guy, but he was like, at the same time, he was swerving his truck towards me, and I kept on trying to miss. Every time he was swerved towards me, I would try to, not let him hit me. So.
Okay. And did he hit you?
Yeah, eventually he pushed me all the way to the far left lane. It was the right lane, so it was the third lane. And when he pushed me to the third lane, he actually clipped me. He really hit me, and then that's when I slowed down. And I was surprised, like, man, what's going on? So when I slowed down, he actually slowed down in front of us, and he slammed his brakes. I slammed my brakes, and then he started reversing towards us like really fast. So I recall in the middle of the highway, traffic going the opposite way, and we're going reverse, and he's chasing me, and I'm in a Ford Explorer, and of course the Dodge Ram is faster, so he caught up to us. He hit me. When he hit me, he got me caught with another car behind me, and he had me there, trapped.
Did you get to see who was driving the car behind you?
Yes, it was a family. It was a guy with his wife and his 3 kids. They were behind me, and he had us there. So yeah.
Just a moment. Excuse me, officer. Yes. Check shirt. No, not you, the person in front of you. Yeah, come around this way. Just one moment. All right, I'm sorry about that. You may continue.
And so were you able to observe who was driving with the car behind you?
Yes, it was a gentleman with his family, with his wife and his 3 kids.
Okay. And when the gold truck reversed into you, could you hear or see anything?
Yeah, he had his pen there for it felt like forever. But I can hear the tires and see the smoke from his tires. Just he had a strap there and he kept on going and going and going. So I really felt like, man, he's trying to kill us, So.
And at this point, did something occur with your seatbelt?
Yeah, my seatbelt got stuck. I couldn't get out. We had a weapon. It was a gun. We showed the cops and everything. It wasn't loaded. We were trying to scare him off, but I couldn't get off because my seatbelt got stuck. So I told my coworker, "Hey, get off!" Try to scare him off, and my coworker got off, went to his side, and pointed the weapon at him. Told him, "Hey, man, you need to stop." He got off. He said, "Shoot me, shoot me!" So he grabs a vacuum pump. A vacuum pump is it's a tool that you use for HVAC. It's about 45 to 55 pounds. He grabbed it. He threw it on my windshield. My windshield busted. So when he threw it on my windshield, I recall running from it because I don't want him to hit me with it because it's pretty heavy. He ran and picked it up and threw it on my coworker, and it landed on my coworker's legs.
And what effect, if any, has this incident had on you?
Oh, my life's changed. I mean, every time I drive, or my mother's driving, or my wife is driving, any car gets close to us, I just tends to like jump and like they ask me. Even my wife gets upset, like, man, I'm driving right. Like it's just in me that I jump. Like it's just I guess she goes, you got PTSD off of that now. So I mean, that's something that's changed when I'm on the highway. I'm driving like a old man now, and then people honk the horn at me. I just leave them alone now. Like
So I'm going to show you what's been marked as States Exhibits P1 through P3 inclusive. Have you reviewed these photos before?
Yes.
Okay. And are they a fair and accurate depiction of how things look from the data office?
Correct.
And in States Exhibit P1, can you describe what is depicted in?
That's me and Augustine and the truck that we're driving.
Okay. And in States Exhibit P2?
It's the windshield where you can see on the windshield on the left bottom side where he threw the vacuum pump at us.
Okay. And States Exhibit P3?
P3, you can tell, like, even when he was throwing, like trying to hit me, you can see the car in front of us. It's another car that actually clipped me, trying not to hit us while he was, move on through that.
I'm tendering to defense for inspection, but state offers these exhibits P1 through P3. No objection, Judge.
All right, state's exhibits P1, P2, and P3 are admitted without objection. All right, any questions?
Very briefly, when your coworker, I was seeing, pulled the weapon on Mr. Aguilar, you said he was saying, shoot me to him.
Mr. Aguilar was saying, shoot me, yes.
Did it appear that he was trying to die by suicide?
Objection.
No, it didn't appear to me because I don't think he was trying to kill himself. I think he was trying to kill other people. That's what I felt.
But did he have a gun or a knife or anything like that on him? Did you ever see Mr. Aguilar?
He was reaching for, I feel like he was reaching for things to hurt us with, because he tried to hurt us with his vehicle. After that, he got out. When he got out, he went into his truck, grabbing stuff. So my coworker had to get on top of his truck and try to stop him from getting stuff from his truck.
And when the gun was pointed at him, he said, shoot me.
Yes, he did.
Nothing further.
All right, all right, thank you.
Thank you.
State,
You have to confirm.
all right, defense, any witnesses?
No, Your Honor, just our client.
All right, Mr. Aguilar? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Edgar Aguilar Hernandez.
Edgar Aguilar Hernandez.
All right, defense.
Mr. Aguilar,
Is the sentencing hearing?
were you
with,
in your right mind on
victims-
March 16th of 2023?
Victims impact statements?
No.
Do you recall any of the events that happened on March 16th of 2023?
No.
No.
Do you have any memory of all of these accusations and evidence that has been brought against you?
Es muy poquito lo que recuerdo. Son partes muy cortas.
It's very little that I remember. They're like short bits and pieces.
Are you embarrassed and horrified to hear all of these things that you were doing on March 16th of 2023?
Of course I am.
How does it make you feel to hear all these things and to see the video and review all this evidence?
Fatal, muy mal.
Terrible, very, very bad.
During the 2 weeks leading up to March 16, 2023, were you under the heavy influence of methamphetamine?
Como ya les había explicado desde el principio,
As I had explained from the beginning,
yo estaba pasando por una crisis de mi vida muy fuerte.
I was going through a very strong, bad crisis in my life.
Yo me quería quitar la vida.
I wanted to kill myself.
No quería.
Yeah, I will not give hints or tips on how to end yourself, but don't put other people in danger. That's just being a moron.
Hacerle daño a nadie, quería hacerme a mí mismo.
I
No a
didn't
nadie.
want to hurt anybody. I wanted to hurt myself, but not anybody.
No a alguien más.
Not anyone else.
Hacer esto. Esto ocurrió sin que yo supiera.
This happened without my knowing.
So you do know that you were ingesting these drugs purposely, right?
Sí la estaba yo ingiriendo.
Yes, I was ingesting them
Para quitarme la vida.
purposefully to kill myself, to take my own life.
And what happened as a result of what happened to your mind because of all these drugs is what led to all of these cases, right?
Exactly.
And you've been in custody for nearly 2 years now, since March 16th of 2023, right?
Sí.
Yes.
And you've obviously been sober and you've had time to reflect on everything that happened on that day and leading up to that day, right?
Sí.
Yes.
And you've essentially lost your family, right? Your wife and your children.
Todo hasta mi libertad.
Everything, even my freedom.
And it's been an agonizing almost 2 years, just knowing everything that happened and pain you have caused to other people, your family, and to strangers, right?
Exactly.
And you're not a US citizen, is that correct?
No, tendría nomás un permiso y el proceso de estar aquí con permiso y seguro se trabajar.
No, I only had a permit and I was in the process. I had a permit to work.
You were a resident and you had a work permit, is that correct?
Sí.
And you were in the process of working with an immigration attorney to become a US citizen.
Residente.
Resident.
And you know that because of these two convictions, that may not happen, and it's very likely that you could be deported to Mexico, is that correct?
Correcto.
Correct.
And you are asking for mercy from this court to give you the minimum, which would be 2 years, with credit for the time you've served, so that you can try your best to pick up the pieces and move on with your life, whether that be in Mexico or somewhere else, right?
Se lo pediría con el corazón
I would ask you from the bottom of my heart
que si pudiera hacer eso,
if you could do that.
pero sé que también se mira mal por los hechos.
But I also know that it looks bad based on the facts.
O sea, cuando lo hace uno intencional, yo creo que sí se merece tiempo.
When you do it intentionally, I do think you deserve the time.
Y si llegué a un juicio, no fue porque sea cínico o sinvergüenza,
And if I went to trial, it's not because I'm cynical or shameless,
sino porque yo no estaba consciente, no recordaba todo lo que pasó.
but because I wasn't aware, I didn't remember everything that happened.
Porque también tengo familia y no quisiera que pasara que le hicieran intencional a la familia.
Because I also have a family and I wouldn't want someone to do intentionally to my family.
Fue por eso que llevé esta trial, no por,
That's why I took this to trial,
no porque sea así.
not because I'm cynical.
No further questions.
State any questions?
Mr. Aguilar, you've been arrested for possession of controlled substance in Austin, Texas, is that correct?
Por una cerveza.
Sí,
no de cerveza.
Yes, over a beer, yes, a bottle of beer.
And do you recall when you were in custody in the Bear County Jail, you met with a doctor to evaluate your mental state?
¿En San Antonio?
In San Antonio?
Yes.
Sí.
Yes.
Okay. And do you recall reporting to that doctor that you had been doing methamphetamine for at least a year prior to being arrested?
Sí.
Yes.
Okay. And so when you were arrested, that was the first time that you had injected methamphetamine, correct?
No, ya tenía más o menos 15 días que era todo de día y noche.
No, it had been like 15 days that I would do it day and night.
Okay. And during this time, you weren't sleeping or doing anything productive?
No.
Honestly, nothing. No dormía más que una hora.
I didn't sleep, but maybe an hour.
And I guess the female victims not testified in the trial, do you recall them when they came in here to testify?
Sí.
Yes.
And you said you didn't know them, right?
No, a
Okay.
nadie
No,
conocía.
I didn't know anybody.
Do you, your home address was that on Rosa Trail?
Sí.
Yes.
Okay, and so you lived on State Street as those victims, correct?
Si viven en esa calle, sí.
If they live on that street, yes.
Okay, and so you followed them from that street to where the incident occurred on 471, right?
Cuando me pregunta que si las iba siguiendo, no recuerdo esas partes que me dicen que
When you're asking me if I followed them, I don't remember those parts where you're.
Okay. And are you aware that the doctor's conclusion was that you were not suffering from any severe mental disorder defect at the time that you engaged in this conduct?
sí, padezco de migraña.
Yes, I suffer from migraines.
Okay. We have no further questions, Your Honor.
All right.
I just
Any
wanted
follow-up?
to clarify one thing quickly. You had been using methamphetamine for a whole year prior to March 16th of 2023, correct?
No, casi, no un año, era como como 6 meses de lo que pasó para atrás.
Not a year, like it's 6 months before what happened.
quite some time before the March 16th of 2023, right?
Yes.
But you were using it in what you thought were lethal dosages to try to take your own life about 2 weeks prior to the incident.
Exactly.
Yeah, I
Are you
don't buy
extremely
that.
sorry for what happened to that woman and her daughters?
Vuelvo a decir, sí me siento fatal, me siento
I will say it
triste
again.
por todo lo que pasó.
I feel horrible. I'm very sad about everything that happened.
And just to be clear, you don't remember them being your neighbors, correct?
No.
But you're just saying you did live on Rosa Trail, and if they did live on Rosa Trail, then y'all were possibly on the same street.
Sí.
But you have no
Yes, yes.
recollection of these people from being your neighbors.
No.
Is there is there anything else that you want Judge Boyd to know that she hasn't already heard in the trial or here today that you would like her to consider before she makes her decision?
Lo único es la condena no sea como si fue en los 5 sentidos.
The only thing would be that the conviction, the sentence isn't as if I had done it in my 5 senses.
Pues como dijo la abogada, si pudiera la condena reducir.
Like the attorney mentioned, if you could reduce the sentence.
All right, any other questions, defense?
Nothing further, Judge.
State, any further questions? All right, any other witnesses, defense?
No, none from the defense.
State, any rebuttal witnesses? All right, the court will hear argument and state.
Judge, we're asking for 10 years and TCJ. I will agree with what the defendant and his counsel have represented. His conduct on that day was embarrassing and horrifying. And the 3 victims, Raquel, Fatima, and Brittany, also found it horrifying. And then the punishment witness that we got in today, Victor, also found it horrifying. So much to the fact that Brittany, Raquel, and Fatima, I mean, Your Honor, I'd ask you to take judicial notice of the evidence that was presented in the trial. But the court was able to observe their demeanor when they came in here, and they're still very much in fear over what happened on that day. And Mr. Lopez, who testified today, testified that he believed that the defendant was trying to kill him on that day. And so that's why we asked to be included.
All right, and then with regards to the lesser included offense?
I'll defer to it.
All right. Defense?
Yes, Your Honor, just brief argument. You sat through the whole entire trial. I think it's undisputed that he was under the influence of methamphetamine combined with alcohol. He was attempting to take his own life. He's horrified to learn. He has very little memory of what occurred on that day, and he's been horrified for the past 2 years to learn more and more details of what happened that day, to see himself on video, to hear from these witnesses and hear their experience. We are not condoning his behavior. He's not excusing his behavior. However, I would like the court to also just consider and take note that he's not a United States citizen. He's had an ICE hold at the jail throughout the time he's been in custody since March 16th of 2023. Because of these convictions, there are second-degree felonies, aggravated offenses. We believe that it's like the likely outcome is that he will be deported in light of these convictions. So based on that, he has almost 2 years in custody. March 16th, of this year will be 2 years. We ask that the court sentence him to the minimum and then come what may on the immigration front. And that way he could try to rebuild his life in Mexico and try to find family. He does have an ex-wife and 3 minor children here that prior to this incident, he did help financially support. His wife, or excuse me, ex-wife wasn't able to be here due to obligations with the children, but we are in contact with her. She did represent to us that he did financially provide for her and the children leading up to this event. So with that, and with all the evidence you've heard, especially his mental state at the time, we ask that you sentence him to 2 years TBC.
All right, and with regards to the lesser included offense?
We'll also defer to the court.
Everybody is deferring to the court on, I want to know what you all are asking for.
Yeah, that's a class C, so.
So it's, as a class C, I believe the range of punishment for that is $0 to a $500 fine. Am I correct?
Yes, Your Honor.
Right, so I think, not that I'm saying that it's not important. There is no imprisonment associated with that. So whether I give a $0 fine or not, and these fines that are collected, no one knows where they go. So with regards to count 1, the lesser included offense of assault, I'm going to do a $0 fine on that one. Now, with regards to counts 2 and counts 3, Mr. Aguilar, I understand that sometimes we do things, maybe we're under the influence of drugs. It is no doubt in my mind that you were under the influence of some type of substance based upon the testimony that the court heard. And based upon the officer saying there was dos equis in the vehicle that had been consumed and some that were not consumed, and also based upon the finding of meth. I understand that sometimes if we were not under the influence of certain things, that we would behave differently. But as you know, and as your attorneys know, voluntarily consuming drugs or alcohol is not a defense to anything. It may be used as mitigation to say, this is why I behaved in a certain way. So I understand that. So no one has addressed this issue for the court. Other than this case, does he have any criminal history? I know there was a mention of him having alcohol or some type of drug substance in Austin. Is there anything else?
Judge, as far as convictions go, he did have state jail trip on a possession less than a gram. That's all that I'm aware of.
All right. Anything else from either side before I pronounce sentence? All right, so this is what I'm going to do. Counts 1, 2, and 3 are to run concurrently. Count 1, there's a $0 fine. And the reason why I'm giving a $0 fine as opposed to a $500 fine is, first off, no one knows where those fine monies go. Legally, and what I've read, I know where it's supposed to go. But when people are looking for those fees that have been deposited, no one can find them. So that's why I'm giving you a $0 fine on that. Counts 2 and counts 3. In each of those cases, the court will sentence you to 8 years in the prison. There's an affirmative finding of deadly weapon in each of those counts. And the court will give you credit for any time served. Is there any restitution for the complainants? I know there was a shattered glass.
They have told us that the vehicle was total, but she wasn't able to provide any.
All right, so, and who was the owner of the vehicle?
It was not held.
All right, so I'm going to do restitution, if any, to the complainant, and nobody presented any restitution for the gentleman who testified for his vehicle. So there will be a restitution, if any, to, just one moment, sorry. To Raquel.
We'll probably
Ildefonso
find out if it is concurrent or
Ortega.
consecutive.
Is there anything else from either side with regards to sentencing?
Nothing from the defense.
And I'm trying to see if I have a trial court certification of defendant's rights to appeal. Did y'all do one?
I don't recall.
All right, thank you.
Does Raleigh have to be there for the verdict? Well, he has an interest in it. So I assume he will be there for the verdict, but I don't know if he actually will be there.
And are you all going to, thank you. Okay. And Mr. Aguilar, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, we are
Yes. All right,
expecting
you
a
have a right
verdict
to appeal because this was a jury trial, but because this is a felony conviction, you're not
Around-
allowed to own or
around 4 p.m. I will have a close. Once we get to 10 to 4 p.m. Pacific time, I will move over to the court stream because I don't even want to risk missing out on this one.
possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And also, I'm going to request for you the therapeutic community. I have no jurisdiction for your placement in the program, but if you let them know that you would like to be a part of the program, they'll see that I requested it as well. And perhaps they can help you with your sobriety and also any mental health issues. Is there anything else from either side?
Not from Steve.
Nothing, Judge. Thank you.
Thank you. Good luck, Mr. Aguilar. Thank you.
It's my pleasure, Your Honor. May I be excused?
Yes, have a great one.
Thank you, you too.
Yeah, yeah. It's in the time in the back.
Regarding guilt or not guilty in the Rocky trial, for me, it's a not guilty. It's not even close. But as I said earlier, I've seen trials with worse evidence get to a guilty verdict. And a few of the things that might lead to a guilty verdict is that they flew in 12. Wally from Paris. Why couldn't they fly in that director who had the prop gun last to testify? That should have been a priority, in my opinion. But regardless of that, were the prosecution close? No, not in my opinion. But then again, I'm not a good litmus test for that because I am pro-defense. My level of reasonable doubt is usually much higher than the normal person. My trick to do, will I reach a guilty or not guilty, is I listen to the prosecution's opening statement. I left with questions. During the prosecution's case in chief, they have to answer each and every one of them until I only have unreasonable questions left. Then I listen to the defense. If I'm at, okay, they answered all my questions, but if the defense then, hey, that doesn't add up, listen to this. This doesn't add up, listen to this. And then you have the rebuttal case. So in the end, if I'm only left with unreasonable questions, I'm at a guilty verdict. In this case, I had probably more questions after the state's case in chief than I began with. So yeah, for me, it is not even close. But you never know. As I said, I've seen worse trials reach a guilty verdict. Trials with worse evidence reach a guilty verdict. The Zachariah Anderson case. There was the only thing that spoke to his guilt was his ex-girlfriend, who he was in a custody battle with. And that one speck, which they claim matched the victim, one speck of brownish substance. And I've been around long enough to know that that could be transfer DNA. That There was literally no way. It was physically impossible because Zachariah Anderson had to travel from his house to that apartment in a specific time. Not one road camera, not one doorbell, not one business camera, not one saw either him or the car. And he had to travel by the highway because any detour and he wouldn't have made it there and back to commit this. So no. And then you have the Dykes case also in Texas, where for me the overwhelming evidence pointed to Rosalio Guterres as the sole murderer. Overwhelming, but they still convicted Miss Dykes, which is mind-boggling. And I've said this before, because the victim was found, or her remains was found, and at almost the exact same spot, the remains of another human was found. For me, that is a clear indication that was the drop spot for somebody who has done it before. So in my opinion, there's a strong possibility that the court and the prosecutor, for his testimony, might have let a serial killer go. But it wasn't up to me, it was up to the jury. So yeah, I've seen worse trials than this reach a guilty verdict. Sentence won't be given today if applicable, correct? I don't think that if he's found guilty, I don't think sentencing will be today. First of all, we are quite late. Usually courts in California end their day at 4:30. They have to have victim statement and all that garbage. I don't think they will want to have Relly's victim statement. And I don't think Relly wants to talk in front of cameras again. So yeah, we will just have to wait and see after the verdict is read what it actually is. Hopefully it's not guilty. It should be not guilty. Not only that, this should never have gone to trial. He should never have been charged, in my opinion. But here we are. And juries are weird.
Okay, all right, thanks. Because I was like, did I miss that?
And this guy here, who attacked an entire family during a drunken meth stupor, we should be happy that they only convicted him on the lesser.
All right, could I see the file on? Is the attorney here on Marie Morales?
Yeah.
Judge, this is supposed to be a plea, but outside still with the.
Okay, all right, thank you.
Okay. The camera crew in California has been allowed in. They have set everything up. All the camera guy has to do is go in and press the power button. But as of now, this is what is shown.
Come up.
They're actually in a, oh wait,
No, they just have a skeleton crew.
okay,
But you'll see if one of them is available to come over.
yes.
And Deputy Laura, are these all the remaining inmates?
Yes.
Yeah, don't forget the lens cap.
Nine, Richard, and 2024 CR 012469, State versus Richard Baker. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Pat Montgomery for Mr. Richard Baker, Your Honor.
All right. And are you Mr. Baker? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Baker, in each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, sir.
Did you understand it?
Yes, Your Honor.
And each cause number, did you review the true bill of indictment?
Yes, Your Honor.
State, and each cause number, are you proceeding, I'm sorry, defense, do you waive the reading of the indictment?
We do, Judge.
State, and each cause number, are you proceeding on the indictment as presented?
Case number 2024 CR 012469. State is proceeding on count one of the indictment and waiving count two.
Any objection?
And with regards to the 2024 CR 012590, state will proceed with indictment as is.
All right. And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Jesus Christ.
And the cause number ending in 90, you're charged with the
Jingles
offense of aggravated
and his
assault with a deadly
claw
weapon.
hoop.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court would grant your application for deferred adjudication in that cause number, if for any reason your community supervision were revoked, the court could sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And the cause number ending in 69, you're charged with
Yeah, law and crime usually sadly get, in most cases, when they get it right, it is because they are so pro prosecution. But yeah, if that is an indication and my chat is an indication, it should be a not guilty.
offense of assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you were granted the application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine. Did you understand? And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine.
All right, we are live. 10 minutes. I need to go and get something to drink because I'm getting thirsty here. some snacks to Mr. Jingles. Oh. So yeah, within minutes we will find out. Oh, Court TV also has not guilty majority. And we have sound. Mandy, guess he's not guilty. It should be, but we never know with the jury. Carl Wood says guilty. Okay. Erica Thorpe, not guilty. Law Malcolm, guilty. Size, not guilty. The vote so far here in the chat on YouTube is 22% guilty, 61% not guilty, and check results, 17%. Yeah. While you're here, if you have not, hit that thumbs up. Please do. Helps the channel. Subscribe if you haven't done so yet. World's End, I would have says he would have taken the deal. Yeah, 180 days in jail. But then that also would have meant he lost. The lawsuit would have been a done deal for Relly. I think he's more scared of the lawsuit. But you never know. Liz Trintle says, I didn't follow this one enough to have an opinion. I tend to break between trials. Yeah. I will have a members only stream later this week where I go through some changes on this channel and what's going on going forward. I will not retire from YouTube, definitely not. I have way too much fun doing this, even though it's stressful on occasion. I've said a few months ago, I said, I will probably have my final stream at my 69th birthday. It's a number of years until then. I hope that 30 years away, my 69th birthday. Oh, thank you for believing I'm 39 years old. While we are here, thank you to Love versus Money. Just saying thanks. Hoping to start a gold trend for those who just want to support. Thank you so much. Nana Misty, hello, Nick in chat. I'm glad you're feeling better. I have been going through some health issues, so I've not been here as often. I'm sorry. You don't never apologize for choosing health before watching this. And Nana Misty has been a member for 10 whole months. Thank you so much. There was a crooked they make a slinky straight. Love versus Money again. Has Mr. Jingles ever had a MJ toy? They're awesome, and kudos to the company in the name. I love a good wordplay. Over here on this side of the pond, all MJ is illegal. We even have regulation regarding hemp over here. So never go to Sweden if you want to have some MJ. Never. It is absolutely ridiculous over here. Angela Thompson, love the beard. I needed a pretty face after watching that mess. Thank you so much. I trimmed it. About 3 or 4 inches. It was time. It was time. And thank you to Lone Star Living for $10. Hope you get better soon. I hope I'm feeling much better. Much better. For you who don't know, I've been ill in pneumonia. I'm currently on the antibiotics, but this weekend it really kicked in, and I'm feeling so much better. But folks, don't grow old. It's a trick. A bad cold when I was in my 30s, I just walked it off. Bad cold in my age, yeah, different kind of animal. Wim 2/14/2025, 30 years with wife and I being a couple. Oh, congratulations. A few days late. Thank you. Yeah. Congratulations. World's End, same Nick, my health has been failing lately. Yeah. Don't grow old, it's a trick. And if you do, well, you can't avoid it, but try to stay as healthy as possible. Okay, it is 4 p.m. Come on now. Check in. We are live. Oh, this is getting nervous. So 3 minutes ago, media is not in the courtroom yet. Well, the cameraman is. The media is outside of the courtroom, and his attorneys walked in about 10 minutes ago. Court TV saying 4:20. Okay. Line, what are you thinking the verdict will be, Nick? It should be not guilty. It should be. But as I said earlier, I've seen trials with worse evidence and guilty verdicts. So I do not know what the jury will say. I mean, we have been watching Lewin yell, scream, throw in tantrums, and yeah, the jury has not been subjected to all of that as we have. And he's been a prosecutor for 30 years. He gets convictions by being an ass, lying in court, and as we see now, altering evidence. So I don't know. I honestly don't know what the verdict will be. I see here on updates on X that Mr. Lewin has arrived. He is walking into the courtroom now. Yeah, I know I'm not very talkative right now. Hey, Mandy, good to see you. Heather Mosher says nothing can be trusted in this case because of Rally, the perjury machine. Okay, I don't see an update on the media being allowed in yet. But we will see that on the live. Okay, the Karen Reid hearing on the habeas corpus motion is March 5th. Interesting. Ghost, Mr. Jingles can make an appearance. He was here just a minute ago. Hello. Let's see if I can get him up here again. who on the jury would find really believable. I don't think any one of them, but sadly, it's not necessary for them to believe Relly at all. What they can convict on the videos alone. It looked like a gun. We heard 2 bangs. For some, that's enough. Mr. Jingles just went outside. They deliberated for almost 4 hours. So for this kind of a trial, a short deliberation, which there are claims that short deliberations often means guilty. I'm not too sure if that is correct. For me, a short deliberation only means they agreed. Also on this channel, we have seen short deliberation end up in not guilty. So, yeah. I agree here with Fire Green Neck is why didn't the defense provide the gun? Where is it? Yeah, at a minimum, I hope that they would provide this movie producer, hey, come testify that you don't know where it is, but you had it. Then at least they would have a person not so closely related to Relly. So that is probably the one thing that a jury might find. If he said he gave the gun back, the prop gun, why isn't the guy who doesn't know where it is, why isn't he here saying, I don't know where it is? You never know what juries will find out. We heard from, or if, I don't know if you heard, but Aidan Kearney had an interview with one of the juries in the first Karen Reed trial a couple of days ago. And it was amazing to hear how the things that we all thought mattered turned up to not matter that much anyway. It seems like that for that jury it was enough. She was there, he was there, he became dead. And that is also something, but that was a murder trial. This is a simple trial. You either have to say, okay, was that a real gun? Yes, no. If no, it was a prop gun. Case closed. Trial over. Verdict not guilty on everything. If you believe, if the jurors believe it is a real gun, then they also have to decide, was that self-defense or defense of others? Was the threat enough to fire the gun twice? They might come back with showing the gun in the first situation, no. But then he attacked them in the second situation. Yeah, that was enough. And I don't know. Yeah, and as Heather Mosher says, the defense isn't required to turn over any evidence, so they don't need to prove it's a prop gun. The state had to prove it was a real gun. Absolutely correct. But once you put up a case in chief where you claim prop gun and the prop gun is gone, many people, including jurors, want to see more evidence. So, but you're absolutely correct. The prosecution has 100% of the burden of proof here in every trial. When juries go into a courtroom and look at the defendant, their thought should be, that guy is innocent. They got the wrong guy. But the prosecution claims, so let's listen to the prosecution, and I have to hold them to every piece of evidence is correct. And as we heard with that Karen Reed juror, once in a while he said the defense didn't create reasonable doubt, which is wild, because it should be the other way around. The defense does not create reasonable doubt. That should be there. It is the prosecution's job to create beyond reasonable doubt. Okay, it is now 13 minutes past. Still waiting for everything to come in here. Let's see here. No real updates. Let's see here. Okay, from Rocky's lawyer, Tacopina is in the hallway chatting. They don't see Rocky yet. Okay. So if he is in the hallway, then we are a few minutes away. X, did ASAP not have security around him? He's high profile by being linked to Rihanna. Well, when I don't know, were they a couple when this took place in 20? Yeah. So yeah, he did have security. He was also advised to have a prop gun, but he also has in a license for real guns. Why didn't he bring security when going down to downtown Hollywood and meet up with Raleigh? I don't know. Also something that the jury can decide, A, he didn't bring a security detail because he had a real gun. They might think that way. We don't know. On crime is now at 23% guilty and 77% not guilty. So X, does Louis know he can't object during the reading of the verdict? I don't know. I assume he will throw a hissy fit, but you never know. I think if the verdict comes back not guilty, I think this will happen. As Berg says, if I'm a celebrity, I'm having at least a bodyguard. Yeah, I mean, I'm having a hard. I can't put myself in that situation because I'm not famous. I'm not a millionaire or anything of the sort. I'm barely a thousandaire. Ghost. Mr. Genius is on the cabinet right now. He just went outside, so I don't know. And thank you to Tammy for 350 via PayPal. Thank you so much. That was earlier today. I must say I missed it. If you're still here, thank you so much. Thank you, thank you, thank you. Travis Scott. Well, the thing with lousy prosecutions and horrible investigators, guilty people should go free if the evidence isn't there. Oh, no. Just a blink. Just a blink. Also, as you might have noticed, you don't get midstream ads here. At least you shouldn't. I do not have that function on here because I know myself that I get annoyed by it. So, replay crew, you will have an ad every 30 minutes or so. If my videos are longer than, if around 15 minutes, it's one ad. One. If it's an hour video, 2, maybe 3 ads. And all I ask in return is thumbs up and subscribe if you haven't. That is how I do it on this channel. I'm also very, very bad. I'm very bad at grifting. I really am. But more, I'm doing okay, folks. I'm doing okay. But I'm going to the United States in September. I'm visiting Utah and Miami in September. So only if you have the means to sponsor that, then please do. If you're sitting saying, hey, bread or $5 to Nick, choose bread. That it's not even a question. Why Utah? Because Jeff, also known as Legal Vices, who passed away just before Christmas, is buried in Utah. And Jeff was my friend. So I'm going there to pay my respect to his family and his friends and visit his grave. And then I'm going to travel around. My cat has a Sumi. So yeah, I'm visiting Utah, and then I'm going to travel around in Utah because I want to see all the movie sites, all the desert things that has been in movies, and just drive around and just visit the place. And then I'm going down to Miami. I'm meeting up with Steve Gosney, and also I'm having a meet up with Mr. Friedman, the attorney in the CNN defamation case, which he won so many millions for his client in that defamation case. So I will be meeting up with him as well. and and also Y&W Melly Trial is in Miami. So hopefully I can get myself into that courtroom. I have no idea what Mr. Jingles is chasing, but I'm keeping my feet off the ground. Do you want some more treats? There it is. Mr. Jingles, how old are you now? Mr. Jingles, 9? Yeah, around 9 years old now. He's been a good cat all this time. Oh, Beck says, my sister visited Utah, Zion National Park, Artis National Park, Bryce Canyon National Park, Canyonlands National Park, Capitol Reef National Park, Moab. Yeah, I mean, if you have suggestions, I will accept any suggestions, because I barely know where Utah is on a map. It is west of the East Coast. Nick, do I have snow here as well? Yeah, we have a little snow here. We have a cold snap at the moment. The past 4 or 5 days, we had somewhere between -5 and -10. Drew by it. It's almost dead middle of the US. Hey. Well, it has deserts. That I know. So yeah. So I will be flying in on September 3rd. I will stay a couple of days in a hotel near the Salt Lake City International Airport. Then I will visit Danny on for a weekend, and then I'm going to travel around Utah while I cover the Y&W Melly trial. Why will I cover the Y&W Melly retrial? Because Jeff covered the first trial, and for obvious reasons he can't, so I'm taking over. Colorado has a 2008 Saab available. I'm looking at a camper to drive around in. Yeah, they are not cheap, but it saves money from hotel rooms. So that is what I'm looking at. So if you choose to sponsor in any way, shape, or form, either by watching all my videos and get me a few dollars in ad revenue, or super chats, or whatever things, or via PayPal, that money this year is going to that trip. I already bought the airplane tickets. Thank you. Now I'm trying to get the funds for the camper van, which is roughly $150 per day for between the 3rd and the 17th. For 2 weeks. Which is around $2,000. Because camper in Utah is perfect. Yeah. Yeah, I will be meeting up with Jeff's son, Vice Baby, here on YouTube. Ruby Mountains. Ow. Mr. Jingles, stop. Yeah, Mr. Jingles has this boop with his claws out. Well, it does get my attention, but yeah, sometimes it just gets annoying. Imagine that, an annoying cat. But he's my cat. Okay. Kathy Russell says they are waiting for the defendant. Okay. Oh, sorry. It's Trinton says, Kathy Russell says they're waiting for the. Yeah, oh, that's a good. The judge with his 1 second, who would notice? Well, many silver medalists knows the difference a second make. That's a good example. Yes, Ghost. Mr. Jingles is innocent of all crimes. Mr. Jingles is he's running the show here. He is the actual owner of this channel. Everything I do on this channel is so I can provide shelter, food, and toys for Mr. Jingles. Am I not Mr. Jingles? Yeah. Okay, it's 4:30. Yes, they're waiting for the defendant. Mel on access update from the court to the media. We are just waiting. So it might be the defendant getting transported from jail or some holding cell or something of the sort, I don't know, to get his ass to court. Travel northern in Utah. NV, what is that? Nevada? It's beautiful. Yeah, I have roughly 7 or 8 days to just drive around Utah and visit sites. Not to bring out, I don't think he's in custody. Okay, then he might have been in a hotel room. Thank you. Yeah, that's actually correct. He's not in custody. He bonded out. Hey, Toria, thank you. He's not in jail. He's coming from home. Thank you. Yeah, I knew that. I don't know why. It might be because it's 1:30 a.m. in the morning here that things escapes me at the moment. You're tired. It's been a long time. Yeah, I've been streaming now for 6 hours and 20 minutes. 6 hours and 20 minutes. And now I did have a nap before I started streaming, but other than that, hour 90 minutes nap, I've been up for 21 hours. So for the sacrifice I do, hit the thumbs up. Enormt, Jonas. You might be stuck in rush hour. I mean, it's rush hour before 4 p.m. in California or in Los Angeles. I don't know. I've never been there. Ooh, look at that. Yeah, here's the federal lawsuit from Karen Reed. Let's see here. We can read that while we wait. Oop. Karen Reed petitioner versus Norfolk County Superior Court and Massachusetts Attorney General respondents. Civil action. Scheduling order. Sailor CJ. On February 18th, 2025, petitioner Karen Reed filed a petition for writ of habeas corpus in this court under 28 U.S.C. 2241, paragraph 2241. She contends that her retrial in Norfolk County Superior Court, scheduled to commence April 1st, 2025, after the trial court declared a mistrial on July 1st, 2024, will violate her Fifth and 14th Amendment protections against double jeopardy. Petitioner is charged with second-degree murder in violation of Massachusetts general laws, blah, blah, blah. Manslaughter while operating under the influence of alcohol, and leaving the scene of a collision resulting in death, according to this law. With just 6 weeks until petitioner's retrial is set to begin, the court issues the following scheduling order to provide an expedited timeline for briefing an argument on the contested issue. Respondent shall file an opposition brief by Wednesday, February 26, 2025. Petitioner shall file a reply brief by Friday, February 28th, 2025. A hearing on the petition shall be held on Wednesday, March 5th, 2025. So this is the scheduling order for that. So that was page 2 of 2. So this is just the scheduling order. Which means the writ of habeas corpus is already in. Respondents must file their opposition by February 26th. Reply brief by Karen Reed by February 28th. And then a hearing on March 5th. Ordered by Chief Judge, United States District Court, Dennis Saylor the 4th. That didn't take long to read. Hey, Jason. Well, we know the verdict has been reached, but we're still waiting for everybody to get to court so they can read the verdict. Oh, there is the memorandum in support of Karen Reed's petition. 700 pages. Holy. Let me just skim through this and see how much of it is there's always evidence and affidavits. Yeah, so most of this is affidavits and the scheduling in the trial and stuff like that. Let me just check here. Kiwi Green, hey Nick, do you think maybe that's why Judge Bev quit the hearing early and didn't allow defense to respond? You heard about what happened today, yeah? Yeah, I heard what happened. We did that, we checked that earlier today. And I think we began this stream with checking that for about that stream was just barely an hour and a half, but it took 2.5 hours to get through it because I had so much to say. So yeah, in the Karen Reed case, the Brennan accused the defense of not being forthcoming, and he said he got these documents from the feds, and then he read from them. And with that, Judge Bev got really, really flustered. And then when she came back from the break, he said, "Oh, I misspoke. I said that we got this from the feds. We didn't. We got it from the defense." Now, I do not believe that was a mistake. Okay, Kathy Russell says, here we go. Okay, everybody is... Okay. Well, I'm live. Let's just check Court TV just to be sure here. Hey, thank you, World's End. Thank you for your £5 super chat. And thanks for keep going. You've done awesome again. Thank you so much. Oh, work tomorrow won't be fun. Work tomorrow won't be fun. But I will have enough time to have a short nap before going to work. It is almost 2 a.m. here at my side of the pond. Let's see, Court TV. No, they're still on their version of the seal. So nothing has started yet. But thank you so much, Dualsen. Thank you so much. It means a lot. It surely does. It surely does. Again, I will have a members-only stream later this week in order to tell my members some changes that is coming to this channel. Positive changes, I hope. I'm starting to learn more and more about the YouTube algorithm and the importance of not putting your all the eggs in one basket. This is why you can see me on YouTube, on X, and on Rumble. My channel on Rumble is Big Nick Starov. Danny on is of the same opinion. Yeah, I mean, Mr. Brennan is a very, very experienced attorney. And he knows exactly who got him those papers. Okay, so according to X, everybody is inside now. And apparently no sign of Rihanna. No sign of Rihanna. Rocky's mother and sisters are in the front row. Okay. Zooming in. Heather Mosher, please don't disappoint us, Yuri. Hope for the best, but be prepared for the worst. Hello, folks over at Rumble. Hello, you over at X. You know what to do. Hit that thumbs up, or in X case, hit that heart. Yeah, and if you have a Rumble account and prefer that platform, the link to my Rumble channel is posted in the YouTube chat. Oof. William says he's already following me on Rumble. Thank you so much. That is so nice of you. Yes, you can. At least YouTube sent this notification. Yeah, usually people get notifications that I'm streaming after the stream is done. So, yeah, not fun. Yeah, this Pacific Coast time is a real stretch. Yes, it is. I don't think I will cover California trials after this because it starts so late, my time. And usually, if East Coast or Pacific time, no, not Pacific, Standard time, Eastern Standard Time is much better for me because I get home from work, I grab a bite to eat, and then the trial starts. So that is much more convenient for me. Even Central Time can work, but Pacific Time, it's too much of a stretch. Now, if it is an absolute nuke of a trial, yes, of course, I will see what I can do. But there are many trials out there. Next trial I'm waiting for is the Karen Reed trial. I'm also waiting for the YSL trial, part 2. The remaining 3 defendants will start in June. And then, of course, the YNW Melly trial in September, which I will cover from the United States. And yes, our politicians currently doesn't really like each other. I don't care. I've said this for many, many years, that if I have the means and funds and everything, I would gladly retire to somewhere in the United States. But I'm not there yet. Maybe if I get to 250,000 subscribers and several thousand viewers at the same time, yeah, maybe I can start thinking about it. But until then, no. And I won't give up my day job. I will still do labor law. Come on, start now. Big Nick needs to go to bed. And if I can get a bit dark, Jeff passed away at 86,000 subscribers. And then after his passing, we got his channel to over 100,000. So folks, get me to 100,000 subscribers before I pass, please. Oh, that was dark. Hey, Ghost is over at X. Hello, X. Yeah, a lot of viewers on X, but not many chats on X. My written updates get quite a bunch of reactions. Hey, fun size. Glad you have in the United States. I'm in a union shop, so I could use you. Yeah. A Swedish union rep, union lawyer in the United States. That would be interesting to see what kind of things I could pick up. Maybe I buy a caravan and live on the parking lot of a Buc-ee's. Naughty Brunette, really, this is a stretch just being in Eastern Standard Time. Yeah, I mean, we've been waiting for almost an hour for this to commence. Let's see. Yeah, I don't know what, because let me see in square feet. My house is just over 2,000 square foot. The barn is, oh God. Roughly 30,000 square foot. And I have 46 American acres of land. Rihanna is in the building. Jill Ems. Good morning, all. Good morning, Jill. Everybody was waiting for Rihanna. Yeah, that's the theory on X, at least. Rihanna said, maybe Rocky said, I'm not going in there until Rihanna's here. Maybe.
notify that the jury has reached verdicts on counts 1 and 2. And I believe the judicial assistant Alex has confirmed that, yes?
We were told they had a verdict, that's correct.
Both sides ready for the jury?
Yes. Yes.
Verdict will be read. With absolutely horrific sound. I have boosted it as much as I can. Oh.
All right, we're on the record with all jurors present, all parties and counsel are present. Juror 9, you are the foreperson?
Yes.
And it is true that the jury has reached verdicts?
Yes, Your
On
Honor.
both counts?
Yes, Your Honor.
All right, you have the verdict form with you?
Yes, Your Honor.
All right, could you give those to Deputy Bennett? All right, what we're going to do, folks, is Deputy Bennett is going to give the verdict forms to juror number 1. Juror number 1, I want you to look at the verdict forms, and I'm going to want to know whether these verdict forms reflect your true and correct verdicts. Juror 2, I'd like you to look over her shoulder so you can review the verdict forms. And I want to know from you whether these are your true and correct verdicts. Once I've heard from both of you, give the verdict forms to juror number 3. Juror 3, look at the verdict forms. Juror 4, look over her shoulder. So ultimately, I'm going to want to hear from all 12 of you whether these verdict forms reflect your individual true and correct verdicts. Everybody understand? All right. Deputy Bennett, put these two in the morning.
Yeah, this is a really odd way of doing this, but
Juror number 1, are those your true and correct verdicts? Juror number 2?
Yes.
Juror 3 and 4?
Yes.
Juror 5 and 6? Juror 5, are those your true and correct verdicts? Yes. Juror 6?
Yes.
All right, let's get the verdict forms to juror 7. Juror 8, look over your shoulder. Juror number 7, those are your true and correct verdicts? Juror 7?
Yes.
Juror 8?
Yes.
9 and 10? Juror 9?
Yes.
Juror 10?
Yes.
11 and 12. Juror 11?
Yes.
Juror 12?
Yes.
All right, all jurors have stated that the verdict forms reflect their individual true and correct verdicts. Alex, read the.
Yes, Your Honor.
The Los Angeles Superior Court, County of Los Angeles. People of the State of California versus Joaquin Mayers, case number BA 508142-01. We, the jury in the above entitled action, Find the defendant. Raheem Mayers. Not guilty.
Not get the audience. Or this is a nice audience.
Hold down, hold down. Has to be run up. Repeat again, plead the jury, above entitled actions, find the defendant, Raheem Mayers, not guilty of semi-automatic firearm in violation of Penal Code Section 245, Section B, a felony, charging count one of the information, this 18th day of February 2025, jury seat number 9, 4%. All right, title, court, and cause, we the jury, and the above entitled action, find the defendant, Raheem Mayers, not guilty of the firearm in violation of Penal Code Section 245, Section B, a felony of charging count 2 of the information, this 18th day of February 2025, juror seat number 9, 4%.
During this trial, I watched you periodically. You did what we asked of you from the very beginning, which is to give both sides a fair trial, pay attention, use your common sense, apply the law, and base your verdict on the evidence. I know you took extensive notes, and you took this as seriously as any jury could. We cannot have jury trials without folks like this. So you certainly have my gratitude. I want to extend to you my best wishes. Again, thank you. The admonition to not discuss the case no longer applies. You can talk about the case with anybody you want to, or nobody if you don't want to. Alex has your certificates of completion. You can take your juror badges with you. Thank you again. You are excused.
Everybody remain seated in the public. We're gonna let the jurors walk up first.
Not guilty of everything. Rocky's going home. A free man. And for Louis, fuck you. You lying sack of human garbage. You altered evidence. You lied to the jury over and over again. You had witnesses lying to the jury. And it didn't work. Louis,
all right, the jury
I'm
is
so
left
happy,
exonerated,
and I'm going to rub it in your face.
You're excused.
Back row.
Exactly. Yeah. No, you cut off your off with.
Everybody in the back row, you need to exit.
Oh. Wow. Finally a good word verdict. Yeah, I will never stop being nervous about these things. Never. Thank you to Law and Crime and to Court TV for providing the streams that allows me to restream with my commentary to you guys. Thank you so much. Thank you guys in the chat for being here day in and day out. Even when I couldn't appear in person because I was ill. Thank you. Mr. Genius, thanks you too. We got a trial with a lot of shenanigans. With a prosecutor who did everything he could to get a conviction, included but not limited to lying, cheating, tampering with evidence, and he still couldn't win. Now, Rocky can go home to his family without this hanging over him. He can go home to his beautiful wife and his children, and he can start create music again. Now, I don't know what will happen to Relly, but I do believe that his civil suit is dead in the water. Dead in the water. I cannot see that civil suit moving forward. If anything, it might be the other way around. But then again, Relly doesn't have any money, I think. I think he banked on winning and put money into property and everything, got his escort girlfriend to pay for it with a promise of, hey, we're going to be multimillionaires. And now it's nothing. Nothing. Oh, so again, folks, thank you. Hitting the thumbs up. Subscribe if you haven't. Thank you to Love vs. Money for your monetary support. The same to Nana Misty, Angela Thompson, Lone Star Living, Derek Croissant, to Wim for being a member for 19 months, World's End for being a member for 4 months, Jessica for 5 months of memberships, and here World's End with a £5 super chat. Thank you all so much. I will have a members only stream later this week. I will go through the Karen Reed habeas corpus. I might do a video on that, but I will probably not stream until Friday because I'm still on antibiotics. I don't know what the backlash will be tomorrow for me being up for 7 hours at 2 a.m. But thank you guys. Thank you for allowing me to do this. Thank you to Brain Socks over at Rumble for your $2 Rumble rant. Thank you so much. Thank you guys over at X. And merch, if you prefer that way. Because not on an unindicted co-conspirator is a good t-shirt in Atlanta. Because them prosecutors will claim anyone as unindicted co-conspirators. I'm going to get a nap. Maybe I will get 2 hours before I have to get up and go to work. Member stream maybe Thursday, maybe Friday. I don't know yet. But everybody, again, thank you for allowing me to do this. Without you, this channel is nothing. Thank you. Until next time, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. Okay? And this concludes this trial. And with a good outcome. And as a goodbye, here is Relly's Lies.
Yeah, Relly told a tale while as a safari. Said he was at the spot like a twisted Atari. Defense attorney Taco, quick with the retort. Caught him in the web, justice cut short. Taco brought the heat, grilling all the lies. Relly squirmed and sweated under those eyes. Proof on the table, evidence stacked. Relly tried to pivot, but the story cracked. Relly lied again, caught in the snare. Truth ain't hiding, it's floating in the air. Struggled with the truth, fighting off despair. Defense attorney Taco had him in the glare. Relly spun a yarn, thicker than a rope. Taco cut it thin, no room to elope. Caught in the act, red-handed with the fibs. Sweating bullets now, like a sinking ship. Clock's ticking loud, truth in the mix. Relly fumbling words, can't fix the these tricks. Taco stands firm,